liquidation provides for sale of the assets, but for beneficial liquidation, that is to maximize the value. So the business of the corporate debtor is carried out. This is the basic purpose, that beneficial liquidation, that there may be more benefits may be derived for the stakeholders. So therefore, the business of the corporate debtor is continued as a going concern, so that the stakeholders may derive more value from the business. And as I have already submitted, that there are certain specific businesses like EPC and some hotels business or something like that, which will derive more value if they are kept as a going concern, rather than selling as a asset, individual assets basis. So there is a regulation. So now I was telling you that the decision regarding going concern. So when the plan is being approved at that time also, or if a decision for liquidation is to be taken in a COC meeting, so the resolution professional keeps this agenda mandatorily under section regulation 39C. So for the COC to take this decision, since the COC is to meeting for the last time practically, though now it is allowed that the COC post the approval of plan may also meet to take any kind of decisions, except for the which may have effect on the approval of the plan. So though earlier that was not the scenario, so practically the COC used to meet last time or while approving the plan. So at that time they have provided for this regulation 39C, wherein the COC is required to take a decision whether the liquidator shall explore the sale of the CD as a going concern, or the sale of debtor business of the corporate debtor. So you all are aware that there are regulations regarding that for the modes of sale. So two of the modes of sale are to sell the CD as a going concern, or only the business of the CD as a going concern. So COC has to take this decision on the last meeting, practical last meeting. So on the approval of the plan, or for decision to liquidate the corporate debtor when it is taken. So then it has to decide. So while recommending the same, the COC shall identify the group of assets and liabilities of the corporate debtor which can be sold as a going concern for commercial consideration. So basically then there is this provision also. So at this stage, if the COC feels that some of the assets are standalone assets which can be sold individually also, so for going concern, if some particular assets where the unit is running, or the plant and machinery lying there or something like that, or the stocks of the corporate debtor are required, so those may be grouped as for the purpose of selling along with the sale as a going concern, and the rest of the assets may be sold as individually, so this is a nice opportunity given that they may get some value monetized while while the process of liquidation commences. So some of the assets may be sold grouped in the sale as a going concern, and then some of the assets may be sold individually also. So those may be sold in the auction. So that is definitely due because during CRP, the assets which are unencumbered only can be sold with the permission of COC. So that's why there may be some assets which are stuck. However, the creditors may not find them to be very purposeful for the business of the corporate debtor. So herein they get the opportunity, while deciding as a corporate going concern sale, they may set aside such assets which may be later course of liquidation. They may even kept them with them as under section 52 for realizing separately, or may be sold by the liquidator individually when the sale of going concern is happening. So such assets may be individually sold by the liquidator. then the resolution professional shall submit the recommendation of the COC to the adjudicating authority while submitting the application of the approval of resolution plan or application for liquidation of the corporate debtor. So basically, when the application is filed, the prayer should specifically say that the liquidation is required to be ordered on a going concern basis, so that the discharge of employees is not ordered, and other whatever directions the honorable adjudicating authority wants to give. So they may give according to this decision of the COC. So they may consider this decision and take to pronounce the order accordingly. So, and the employees, workers, directors are not discharged. So that way the order shall come like that. So otherwise, if the order is like discharge of workmen, employees, officer, then there may be a state of a little bit, you can say, confusion state, wherein it may not be clear. So whether the order is coming it as a going concern sale or as this thing, it is for individual sale basis. So definitely there should be clear prayer and giving in all the things clearly that this is required. These are the assets which are to be grouped as a going concern. These all should become part of the prayer. So not only in the application. So better would be if these should be clearly stated in the prayer, and so that the order of the adjudicating authority is clear as to what all assets can be are kept out of the going concern sale, and what assets, how the process of liquidation is to be done later on. So all that should be very clear in the application itself. That will become the basis of the keeping the CD as a going concern and the facilitating the sale. So there may not be any later on there may not be any confusions. So then about the sale process, the regulation 32 provides that. So as I informed you, besides the first four modes, which are practically about the sale of the assets individually. So for, this 32E says the corporate debtor may be sold as a going concern. 32F, which is for the business sale of the business of the corporate debtor as a going concern. So however, liquidator cannot sell the assets unless security interest has been relinquished. Even during the for the sale as a going concern, the whatever assets are there which are forming part of the going concern, these need to be relinquished to the liquidator. So the creditors have to mandatorily, relinquish those assets which have become part of the going concern sale. So they cannot exercise the right under 52 to keep such assets out of the purview of liquidation. These are mandatorily to be provided to the liquidator, since the sale of as a going concern or keeping the CD as a going concern, these are as per the decision of COC, and maybe as per the circumstances, these are required to keep the CD as a going concern. So rest of the assets, I think somebody's mic is not mute. So please mute your mics. Please see, madam. So regulation 32A, which is for sale as a going concern. So where the COC has recommended the sale as a going concern, or the liquidator is of the opinion that sale as a going concern shall maximize the value of the CD, he shall endeavor to first sell the corporate debtor as a going concern. So going concern sale should be taken up first before any assets are put to sale. So then the group of assets and liabilities of the CD as identified by COC under regulation 39C shall be sold as a going concern. Definitely, we are all clear about that. So where the COC has not identified the assets and liabilities under 39C, so then these regulation 39C are of the regulations of CARP. So not of liquidation regulations. So 39C, you must not confuse. This is CRP regulations, not liquidation regulations. So then the liquidator shall identify and group the asset and liabilities to be sold as a going concern in consultation with the SCC. So this is also very important point. So then liquidator has to identify. They have used the word shall, so that these assets may be put in under the sale as a going concern. So when the SCC meeting is conducted in the first 7 days, the liquidator has the opportunity in that stage itself. He should do this task. So he should not wait for other SCCs later on, because while filing the claims, the creditors have to take this decision. So while filing the claims, they have to decide about relinquishment and all. So this will majorly affect the claims and relinquishment of assets also. So the liquidator shall endeavor to take this decision in the first SCC meeting, which is conducted in the first 7 days. So at that time, he should identify and group the assets and liabilities to be sold as a going concern. So he should not wait for later SCCs. Otherwise, if somebody doesn't relinquish that assets which are required, and 39C, they have not taken the decision, so then it may cause some confusions later on. Then the liquidator may sell the assets of the corporate debtor under clause E of regulation 32 exclusively only at the first auction. So 32A now also says that exclusively the first auction shall be for sale of the assets of the corporate debtor under 32E. Means the going concern sale shall exclusively conducted in the first auction. And later on, though, he may also combine the sale of individual assets. So, but in the first auction, it should be exclusive. So later on, it may be also, the option for individual sale shall also be there. So this is the provisions regarding the sale. Though we are covering all the legal provisions at one go, so then we will come to the practical operational part about the keeping the CD as a going concern. So firstly, we are taking up all the provisions of law, so that we are clear that what does law provides regarding the going concern sale or going concern CD during liquidation. Then regulation 35 regarding the valuation. So valuation of the assets. So the law is clear that the CRP, the valuations taken during CRP may be taken during the liquidation process. However, the liquidator may appoint fresh valuers in the first 7 days for of liquidation to two registered valuers for valuing the assets or businesses. So now, when the CD, now here comes the difference again. So when the CD is kept as a going concern, the liquidator may also opt to value the business, though the business may also be valued during CRP process. So during CRP, if he has taken the valuation as of the business, so that valuation may also be taken up as the liquidation value of the business. So may be taken up as a realizable value, and the reserve price may be fixed accordingly, or the value of the business may be taken up for when the CD is kept as a going concern, and realizable value may be derived at by the valuers during liquidation. See, here the valuation is very important. During CRP, the valuation plays a role only for taking up of the decision by the creditors. So that they may consider or may not consider. That's the commercial wisdom. There, the valuation is only a parametric thing. There, the valuation is not for very compulsorily required. So, but during liquidation, so valuation will be very important, because the reserve price is to be fixed. Even for sale as a going concern during liquidation, the reserve price is required to be there. Then only, he may put up the corporate debtor as a sale. So without reserve price, the sale is not possible during liquidation. So because Schedule 1 of liquidation regulations provides for the entire process, and that can be done through auction only. So so therefore he has to be careful during liquidation that better would be to get the business again, because there may be change in circumstances, change in the value of the business during the entire CRP process. So time has elapsed, or maybe there may have been some time taken up during the process of adjudicatory process of by the adjudicating authority. So better would be to have a fresh valuation of the business for arriving at the realizable value to be used for fixation of the reserve price during the liquidation process. So this should be done in the first 7 days itself. Yeah, so we may move further after the valuation. So then it is clear that the registered values shall independently submit to the liquidator the estimates of the realizable value of the assets or businesses. So average of the two estimates received shall be taken as the value. So there have to be two valuers of the assets or the businesses. So if for the assets, then again, there can be separate valuers for plant and machinery, land and building, and SFEs. So for the business, there may be some entity or something like that. So they may conduct and accordingly. So now Schedule 1, as I was referring, which provides for mode of sale. So it is clear that the reserve price shall be the value of the assets arrived at in accordance with Regulation 35. So Regulation 35 provides for both the valuations. If either the liquidator may opt to use the value arrived at during the CRP process, and or then a fresh value may be taken arrived at during the liquidation. And for that, first 7 days, the valuers have to be appointed. Though in first 7 days itself, SCC is to be called for, so it would be better to consult with SCC before appointment of the valuers, which will definitely help the liquidator, his own safeguarding his own part. So basically, using this value, so as Schedule 1 provides, the reserve price may be arrived at in consultation with the stakeholders creditors consultation committee. So and when the liquidation, this going concern sale is happening, so the reserve price will be for the business, but it should be taken up into consideration that the assets only, the assets should be used in that business valuation, which have been kept for by the COC for to be included for sale as a going concern, sale of CD as a going concern. So the other assets may be valued separately, or for them the valuation during CRP may be used. So this thing shall be definitely kept in mind while fixation of the reserve price. So, and these things have to be specifically considered for all the steps, the valuations, the the prayers in the application, the fixation of reserve price, the auction notices. So, and also for during the decision being taken by the creditors, the liquidator may guide the creditors for filling up their forms for claims, submission of claims, that which assets they can relinquish, they can decide not to relinquish, or so he should guide them in the first SCC itself, that compulsorily they need to relinquish the assets which have been included by the COC for being part of the going concern sale. So this needs to be guided to the creditors, so that there may not be confusions later on or litigations, basically, because we are all aware that IBC is being affected by the numerous litigation. So to avoid all this, so these aspects should be very clearly guided to the creditors and should be kept in mind by the liquidator, so that there may not be any kind of issues later on. Then claims part of the employees workmen. So when they are filing the claims, because the liquidator is running the business as a going concern, he should guide them also that terminal benefits they need not claim, since the CD is being kept as a going concern. So they cannot include their terminal benefits like gratuity and PF while submitting their claims on the liquidation commencement date. Only if there is any unpaid, wages or salaries for pre-CRP period, because the CD's business is already continuing as a going concern. So their wages, salaries, if the work is continued, they will have become part of the CRP cost, since being covered by Section 513C for cost of running the business. So the wages and salary of the workmen will be part of the CRP cost. But however, due to CSC Supreme Court's decision in a matter that if this wages of the workmen, etc., will become part of the CRP cost only if the work has been carried out, the business has actually been carried out. So this should also be kept in mind. So, however, they need not, if the business was carried out, there is some pendency of the wages or salaries of the CRP period, so that they do not need to make it part of the claim, since they will be part of the CRP cost automatically and will be paid in priority. However, if there is any pre-CRP dues in wages or salaries, that they may submit during the liquidation period, and they may include in their claims. However, the terminal benefits, since they are not discharged on the liquidation commencement date due to the COC's decision to keep it as a going concern, so they may not include the terminal benefits in the in their claims to be submitted for the liquidation process. So these things should also be kept in mind and may be guided, so that there are no litigations later on. So it's all to be coordinated by the liquidator. So all these things, shall be kept in mind. So these are important points. So that's there. So then now the legislature part is we have already done. So now will come the operational part. However, till now, if there are any questions for the legislature part, so I would definitely request the participants, if they want to ask questions regarding the legislation part, so they may ask, because now we will come to the operational part to keep the CD as a going concern. So any questions regarding the legislation part? So everyone has understood the legal provisions and whatever points I have told to keep in mind, Mr. Ashish Shah, you want to say something? Mr. Ashish Shah, please say. I can't understand. You are saying no, sir. So, is it about not understood, or is it about that no questions? I understood. Thank you. So, fine. Thank you, Mr. Ashisha. You have understood. So, everyone must have understood. That's why, okay, fine. So, then let's go ahead to the operational part. So, what is liquidation? So, company liquidation is a process rather than a term. The liquidation is the procedure under which a company is wound up. Liquidation under IBC may be voluntary or compulsory. The liquidator's function is to convert the company's assets into cash and cash equivalents, and to distribute the proceeds among the creditors. There's some basic things about liquidation. So basically, it is about converting the assets of the company into cash or cash equivalent and to distribute the proceeds among the creditors to the extent possible. Any surplus is then distributed among the members of the company under liquidation. So this is basics of the liquidation process. So, operational part for a sale as a going concern. So while it is one of the methods of sale, so the reference may be made to the report of the Insolvency Law Committee dated 26th of March 2018, wherein the committee examined the term going concern. So now we will come to the term going concern. What does it mean? So the phrase as a going concern implies that the corporate debtor would be functional as it would have been prior to initiation of CRP. As the corporate debtor was functioning, so it will be functioning like that only. So other than that, the restrictions put by the code. Yeah. So that is definitely there. So there are certain restrictions like in CRP, the board of directors powers are suspended and during liquidation, as I told you, the employees, workmen definitely will not be discharged. However, the board of director is terminated. So that is the difference. So besides that, the going concern means it is a functional business of the corporate debtor as it was prior to the initiation of CRP. So there is no difference else than what is provided in the code. So yeah, definitely the liquidator or the this resolution professional has to take decisions after approval of the COC or the SCC, and whatever provisions are there in the code like approvals or the regarding signing of the contracts, agreements, what all he can do, change in management he has to take approval of the committee. So section 28 is there and of IBC, which will provide for all those acts wherein the liquidator has to or the RP has to take the approvals. And during liquidation, though approvals sometimes may not be required, but consultation is with the SCC shall be done, and morally also, even if some certain topics the code doesn't provide or the regulations do not provide for consultations, and also the code or the regulations do not mandatorily need the liquidator to accept the consultation by the SCC. However, morally the liquidator shall consult, and if majority of the creditors are of certain opinions regarding the going concern process, he should take guidance. If some major renovation is to be done in a hotel, so a huge expenditure is to be incurred, he shall go before the stakeholders committee and take their advice, take their consultation, and mandatorily should follow that, so that there is no litigation later on. So certain things are to be done to avoid litigation. I have seen in many matters there are huge litigations between the creditors and the liquidators. So liquidators shall not particularly literally see that only these topics he should take the consultation, and also should not literally take the meaning of not the consultation not being made mandatorily to be followed by the liquidator by the law. He should morally definitely take the consultation into mind. So though there is a provision that if he differs from the consultation given by the stakeholder, he should include this in the progress report. Now there are certain matters wherein the consultation is being made mandatorily to be accepted by the liquidator. That will come to that later on. So there are some major amendments coming in, so which have been proposed in the discussion paper. So we'll come to that. So, but however, in any case, the creditor shall be taken into confidence, and it would be always better for any professional or the liquidator, I should say, in this specific case, he should take guidance or the consultation from the stakeholders consultation committee, and should try to go by that, rather than just strictly or literally taking the meaning of the consultation not being mandatory and taking his decisions and against the advice of the creditors because their stake is involved. So we have a limited stakes or the limited role to play, though, and their money, their stake is involved, and they are going to be affected by any kind of decisions. So for going concern, for any major decisions, he shall take the consultation of the stakeholders committee. Like I told you, renovation or maybe the change in management is required. Some additional employees are to be taken. Some very important person is to be removed or is to be inducted. So auditors are to be changed. There may not be during liquidation all those compulsorily all those things which are there in section 28, which are mandatorily required to be approved by COC. And but however, liquidator shall also take consultation from time to time, even for sale of assets, fixation of those sale of assets, consultation is required to be taken. But sometimes people say that yes, it's not mandatory, but better to go by that whatever consultation has been received, because it's their stake, it's their money which is at stake. So definitely liquidator from time to time during going concern business should advise. Now proposals are coming, wherein it is being said that the stakeholders committee or the COC shall play a role of board of directors. They should be equated with the board of directors, and liquidator maybe or the RP maybe be a CEO. So he should be considered as a CEO of the company. So he should play the role of a CEO who works under the directions of the board of directors, which are COC or the stakeholders committee. Though it's not there in the law, but practically it would be good for all of us that we take ourselves as the CEO and as an RP or liquidator, and should restrict ourselves in that role and abide by the directions, instructions, and try to take instructions or directions from the SCC or the COC and take decisions as per their directions. Any big sales of the stocks or a new client is being inducted, pricing matters should be taken to the stakeholders committee. The even pricing of the goods, if it's a major policy decision about the valuation or the price or about the process, maybe he needs to make a major change in the process of the production or manufacturing or some trade or any major policy kind of decision of the business must be definitely taken up to the stakeholders committee, and their advice should definitely be considered by the liquidator and shall be taken up accordingly. So further, there is a note published by IBBI which defines the going concern. Going concern means all assets, tangible or intangibles, and resources needed to continue to operate independently a business activity which may be whole or a part of the business of the corporate debtor without values being assigned to the individual asset or resource. So it is a very technical, kind of meaning. So all the assets, tangible or intangible, resources needed to continue to operate independently a business activity. So when the COC takes the decision about inclusion of certain assets for the sale as going concern, definitely this definition will come to as their rescue, wherein it says clearly that whatever is needed to continue to operate the business activity, or which may be whole or part of the business of the corporate debtor without values being assigned to individual asset or resource. So here we can take a cue from here, wherein they say that values need not be assigned to individual asset or resource. So the business valuation may be got done during liquidation, wherein the assets which have been found by the COC to be the assets which are needed to continue to operate the business of the corporate debtor. So those assets may be included, and the business as such, what we call it as a enterprise valuation, may be got done by the liquidator during the liquidation process, and accordingly the reserve price may be fixed for sale as a going concern. So definitely it is a nice clarity. So what is the difference between sale of the corporate debtor as a going concern and sale of business? So E and F, So 32E says it is crucial to identify the distinguishing factor between going concern business, sale of the CD of 32A and sale of business of the corporation under 32F. So under both the clauses, assets are not sold by way of slump sale or piecemeal sale. The acquirer buys the business with assets. The business can be either operate under the existing brand structure or not. Seemingly, the only difference is between the corporate debtor as a going concern and business of the corporate debtor is that the former situation, that is, when we say CD as a going concern, the corporate debtor itself will be retained, will not be dissolved, and will be transferred along with the assets. Okay. And however, in the latter case, the business will be transferred as a going concern without transferring the legal entity. And therefore, there may be a particular contract awarded to some corporate debtor, like a road building contract, some kind of such contract with NHAI is there. So somebody may be interested to buy that contract, that business. So they may come forward and say that business may be assigned to us. So we'll build this road. And however, we are not interested to buy the corporate debtor itself. So that is definitely possible. There should be a clause in that contract that may be assigned to some other person because a third party is involved. So definitely NHAI's permission may be required. So all this have to be kept in mind. Or there may be certain business wherein, so the clientele, basically it will be about the clientele. Like I have an automobile unit wherein it is an OEM to certain nice names, brands like Tata, etc., Tata, Bajaj. So somebody may be interested that, okay, we may be assigned this business and we may be given, subject to definitely in any kind of business where clients, the third party clients are there, it will be subject to their approval also. So that business may be sold under 32F. And practically speaking, generally, it is always, the sale of corporate debtor as a going concern. So hardly I have seen any business being sold under 32F. So because, when it is a corporate debtor, business automatically comes along, and, there may not be that complexities of taking approvals of the third parties, etc., or some things like that. The corporate debtor is transferred accordingly. The required assets for keeping it going concern, required infrastructure, whatever is there, it comes along. So that is there. But though the law has definitely provided for both the things. So we, in our processes, we have done 2 or 3 sales as a going concern during liquidation. Corporate debtors have been sold. One of that is Apex Builders, which is a kind of an EPC company. So we sold it as a going concern. They are into prefabricated, structures for the metros and all. So that we have sold. So now the liquidation was initiated by NCLT by its order, wherein specifically directed that the corporate debtor is to be sold as a going concern. So I'll show you that order. So because this was because it's an EPC company. So as I have told you, that EPC companies definitely would be better sold as a going concern. So we'll show you the order.
Sir, I'm just displaying the order. There's some error. Just give me a moment, sir.
इवन वो वाला जैसे खुला था उससे भी पढ़ा जा रहा है.
No, sir, it is getting auto closed. So just give me a moment, sir.
Mm-hmm. So till then, if anything we would like to discuss, you people can also give your views. If you have certain views, we can add. Every one of us has our own experiences. So anyone can also share their views. So if even if it is similar or different or any kind of, maybe I may have certain different kind of experience. Everyone can learn from each other. So definitely, if you want, you can give your suggestion or. Hmm. So this is the order. So they have firstly written everything about, how the process. So here it is mentioned, order of moratorium they have definitely mentioned. Under section 33(5) is to be there. Then they say the liquidator is directed to proceed with the process of liquidation in the manner laid down in chapter 3 of part 2 of IBC code and in accordance with the relevant regulations. So this is liquidation process itself. Then further, liquidator is directed to act in terms of decision of a appellate tribunal in company appeal so and so Y Shivram Prasad versus S Dhanapal, decided on 27 to 2019 inter alia, to ensure that corporate debtor remains as a going concern. So it is specifically mentioned about Y Shivram case, that it has to be kept as a going concern. Liquidator shall follow up and investigate the financial affairs in accordance with 35 and follow any pending application, submit preliminary report, and copy to be sent to the financial creditors, corporate debtor. So they have nowhere mentioned about the discharge of the employees. Otherwise, you will generally see in the liquidation orders, it is mentioned that the employees and workmen shall stand discharged from the date of this order. So that has not been mentioned. So particularly has been ordered as a going concern. So such kind of orders we shall obtain, and these will ease the process. So this is there. Then employees, workmen, as I have again and again saying, that are not to be discharged. Then running of the operations of the CD were ensured even during liquidation. We completed one of the project of Kochi Metro. So where when the project was completed, delivered during the liquidation process. So yeah, and even during the lockdown period, so regular production was maintained, and the existing and prospecting clients were approached for the work orders by the liquidator. We have very nice names there, Shaji Polan something करके वो जो है Shapu. They are the clients, and Tatas were the clients. Then metros were the clients there. So they work approach for the work orders by the liquidator with the support of senior officials of CD to keep the CD as a going concern. See, the basic thing when you run any business, we shall definitely take the employees and workmen into confidence. They should not be feeling afraid. They should not be feeling, shaky about the existence. They should not be under doubt that this business is going to be closed in any case. This is only an eyewash, so company will be dissolved in the end of the day. They should not be spectacle about their existence or their employment. So we need to clear their doubts. First of all, we should properly educate the employees, the workmen. We should have regular town hall meetings. Better would be every week or even virtual mode if you so require. Now that is also a very nice mode that you can get connected. So we should keep on time to time, when they give you support, that definitely matters a lot. I am running around at present 6 7 big units, as a going concern, including a 5-star hotel, including automobile units in Pune. I'm sitting in Delhi and running in Lanavla, Pune, Bangalore, Calcutta, and Hyderabad, Rajamudri, then Delhi. So many units. But basic thing is you shall try to take their employees, the workmen, into confidence. They should even feel more in a better position than they were with the promoters. Definitely, when the business was under stress, it would have been that the occasions would have been there that they were not being paid timely. Or, but in our cases, we only run if we know that we can take out money for them. We would be able to meet all the cost of running that business. That should not fall to COC. When we see that viability, then only we decide to keep it as a going concern, so that there should not be unrest, there should not be a feeling of non-confidence, or there should not be any feeling like a spectability about their employment should not be there. So the employees workmen are the major resource and the major asset, the biggest asset of a going concern. So we shall definitely honor their concerns, and would definitely we should try to resolve each and every issue they bring in, so that if we ignore that, or if they are not in that confidence of running a situation of the business, then definitely it would be very difficult for a professional coming from outside all the way, just appearing by means of an order to keep that business running. There will be issues, there will be unrest, there may be problems, there may be strikes or daily kind of things, and tussles between with the management, with the employees, etc. So it should be avoided, and only if you are able to build that confidence, or you are able to they are also okay with the running of the business, then only this decision about keeping the going concern shall be taken. Else it would be a trouble for our own self and for them too. Else they can look for their employment anywhere else. There is no point if we feel that we ourselves are skeptical of giving them, paying them or regularly, or we are skeptical about the running of the business. So the decision should be very very cautiously taken, and only with their support, only with their support. And sometimes it happens, if you are able to win their confidence, you may remove from their minds the what has been fed by the promoter, that this professional, sometimes it happens, when you go, the promoter has already made them understand that, yeah, this professional, he has come to only to on their fees, and they'll be here for temporarily. Ultimately, we are going to take up again So you should follow our directions. They may create troubles for you. So we have to clear from their mind, because we should say, had he been that nice of a person, he would have, kept the business running. He got a facility from the lenders. He got, all kinds of things in hand, but he was not able to run. So they are in a better position now, because the new management will take over, which must be a good management, will take care, will keep them in consultation while deciding about the plan or the sale, while the sale of CD as a going concern is done, so that they would definitely come out of that whatever deception has been created in their minds by the promoters. So that is required. That is definitely required, and that is a basic element of running any business. So that basic element is the employees and workmen. Otherwise, if we miss that element, so we would not be able to run that business without any disturbances or litigations or unrest. So this thing is definitely required. Then is SCC should be periodically apprised about the business operation, and the same should be duly monetized. We'll show you one of the minutes of this company itself. So wherein we have recorded the advice of SCC and the appraisal to SCC about the business operation. So Saurabh. So the meeting of the stakeholders. So this is about the buyers who had appraised. So these minutes are very important. Buyers have also come. So we'll gist of orders procured after. Yeah. So this is how we are appraising. ऊपर से शुरू कर लेते हैं थोड़ा सा. I think ऊपर भी कुछ बोला हुआ है. Yeah. Litigation, business presentation. Yeah. So the liquidator briefed that in view of the COVID-19, see, this was lockdown was going on, and consequent slowdown in the economy coupled with the ongoing liquidation proceedings against the CD, it is becoming very difficult to procure fresh orders, because the clients are also skeptical that we'll close the business. So we have to build the confidence in the employee or the clients also. So they should also be confident that if the liquidator would be able to, conclude the business and deliver the product or the orders. So it is becoming very difficult to procure fresh orders and thereby keep the CD as a going concern, as mandated by NCLAT by its orders. Also, the sales team of the CDs hence being motivated continuously for procuring fresh orders. During the discussions with the security stakeholders, it was apprised that post commencement of liquidation process on 9/1/20, the liquidator has managed to procure work orders for 8,500 tons, valuing about 16 crores, that too without furnishing any bank guarantee, only on the basis of comfort letters being issued by him to the clients about the safety of or the right of the on the material supplied by them for fabrication. So we gave them comfort that the material they are supplied, so that would be available for them to pick up in case of any exigencies. If they are not satisfied, they can definitely take out the material and close the order immediately. So we provided them all the comfort and assurances required. Then only orders were procured. Otherwise, in the liquidation process, no client would like to depend on a company which may close any day. So this will depend solely on your, conduct, so that you are getting business. Otherwise, it's most difficult to, get orders, fresh orders at least, from clients, and that too wherein it's a long running order of like EPC, so which needs time to conclude, and It's very important for most of the clients like Metro. You will have a very particular part of the work, but their entire project of running a metro from one place to other will depend on your completing the part which you are being assigned. That may be maybe 2% of the entire project, but however may be very important. So no client would like to depend on a company which is under liquidation for such a important or strategically important project. So that depends on how you are giving them confidence, how you have run it during CRP, what was your conduct and what was their experience during the CRP process, or how they are satisfied with your to your way of running the business and your way of approaching them. And creditors also will play an important role. They are generally big lenders, so if they are also with you and you have kept them in confidence, so that would also help you in running that business during liquidation, because it's a very shaky situation that any day you may say that, oh, we have to close down the business and sell the assets of the company and dissolve the CD later on. So then the clients are very difficult to give get confidence out of such proceedings. So this is a gist of orders which you see. We have procured 8,500 metric ton of orders for value of 16 crores from clients like Shapur Polonji, and Navtar is okay, Zetwork, Artson, NCC Limited. So these kinds of clients were there whom we got the orders. So these are the cash flows we showed. On query from a representative of ICC Bank, the liquidator apprised that efforts are being made to procure only short-term orders. See, so we are ourselves taking precaution that only short-term orders are taken up, because we are not sure if we are not able to sell as a going concern, we may have to close down the business and take orders from the adjudicating authority to closure, because definitely it's being kept as a going concern by specific orders of the NCLT. So we may have to go approach the NCLT and ask for, allowing us to sell the assets on individual basis, and that the sort of wait, please. So yeah. So that the existing orders are expected to be executed within next 3 to 4 months, since only once favorable order is received from NCLAT, sale process of CD assets shall be set in motion. So in this process, NCLAT had even stayed the process of sale of CD even as going concern later on. So due to some appeal by the promoters. So now see the cash flows we are giving, that we have received around 21 crores, 91 lakhs during this liquidation proceedings, and 22 crores was available, out of which wages were paid for 1 crore 36 lakhs. 12 crore was 95 lakhs was the operational expenses. Statutory dues have been paid for 2 crores 20. Now, please, further, yeah. Then transporters paid, then exile, all this done, then we have even been able to maintain balance in the FDRs. So this is the thing, So total balance with us was available 4 crores. This is all the cash surplus generated by the liquidator during this process. So 2 crores more was lying with SBI. So total 6 crores was the cash surplus. In my case, when I am running a hotel, 5-star hotel, I have 35 crore as cash surplus generated during CRP. So if you do such kind of conduct the business in this manner, so definitely you will gain the confidence from the creditors, and you will be your words will be honored by the creditors. Like some people, some professionals say they are facing problems with COC. That is the place where they get most of the contentious, things like getting a pool of funds or regarding their fees. So when our own conduct is giving confidence, and we are conducting the business like in a confident manner, and with their advice, and keeping them in confidence, so definitely there may not be that much contentions with the creditors. So this way you can keep them in confidence and give them information from time to time about everything. So discussions were held on FDR position of CDA in the insolvency committee, was briefed by liquidated, decided that updated statement will be incorporated further, advised to share debtors position. And so see, you are receiving the advice also for perusal of the stakeholders while discussing on the FDRs, the CD. We have enough time, Saurabh. So with the liquidation, it is being held for last few months, which I sure to be remit post conclusion. Revised progress report with the FDRs of 6 crores were there. Liquidator also apprised to place before the following business figures: the total projects completed post CRPs, post past statutory dues paid during. We have paid even the past statutory dues during our liquidation process or CRP process. Then production, dispatch, sales, these are being informed. Then liquidation cost of rupees 1 crore 26 lakhs have been incurred till date and paid entirely from the operations of the CD. So then the creditors won't have any problems in allowing you to have your fees and all that. So this all is there. So then it was taken note of. Yes, now following of reports with NCLT, but ये तो ठीक है, from time to time everyone does that. Then is comes a sale. So क्या है ये? Okay, this is about the
Not in this, sir. Not in this. It is in subsequent.
okay, that is in subject because NCLAT had a state. Yeah. So let's come back. Yes. So minutes I have shown you. Then cost incurred for to keep the CD during liquidation should be apprised to SCC, like I informed you. इसमें क्या है specifically दिखा दो एक बार. The format in which we do inform the cost incurred. Insurance ये सब तो हो गया. Yes, reports etc. Liquidation cost, yeah. So we had discussed regarding the operational issue, cash flow etc. Liquidation cost also, legal charges have been incurred, liquidator fees, because the fees during CRP was continued for 3 months in liquidation, 230 for section 230. It is there in law that the fees as which he was drawing as a RP would be continued. So that is there. Then professional charges, then publication expenses, then security guard charges, then salary expenses. So all this amounted. So this all cost of the liquidation cost was also well informed to the SCC, though it was being met out of the operations. So they were being kept in complete, faith and confidence. Yeah. So then, later we came to when the NCLAT allowed us, we got the process for sale approved by the SCC. दिखा देते हैं एक बार. Yeah. Sale of CD and the assets. So option 1, we gave them both the options that one is to maximize value. Sale as a going concern in its totality, along with its employees' workers, again that reserve price of at a reduced reserve price. It was a price that the reserve price may be reduced up to 50% in the second e-auction. So this is about second e-auction. First had failed. So where e-auction fails, so or 10%, whatever they decide, it was a price. Two investors were have convinced their interest to buy the CD as a going concern, but at a reduced price than the one fixed in first e-auction. though have not submitted their interest quote for buying the CD as a going concern. You know what happened is, first e-auction also we sold as a going concern, but that person deposited 25% and later on could not deposit the balance 75%. So that's why, yeah, that's why NCLAT matter was going on. That person then went to NCLAT since we forfeited that 25%, which was around 28 crores. So we forfeited that amount, and he had approached NCLAT to against that forfeiture. So that's why second auction took some time. So first auction was conducted as going concern. However, he failed to deposit. We forfeited that 28 crores. During the resolution process, the plan maximum which was received, it was 70 crores only. So during CRP, we kept the fair value as reserve price 105 crores something. Was the price, or 110 crores something like that. So in the first sale itself, it was successful. However, that buyer could not deposit balance 75%. So that's why NCLAT matter was going on and against the forfeiture. But we have been able, we won up to Supreme Court. So that forfeiture was upheld by Supreme Court also. So then we went for a second sale. So this is being discussed about that. So then two more buyers came in, which were interested in buying the CD as a going concern in writing as asked for by the liquidator. Yeah, next. So then option 2. Then because first auction as a going concern had been conducted, we had the option to sell it as a CD assets individually also. So this was second option given. Then third was because Pantnagar a plant was closed pre-CARP. So Pantnagar could be, we said, sold separately, and the Nagpur, which was a running unit, would be sold as a going concern. So approval from NCLT, because NCLT had ruled about sale as a going concern. So for all this, we could have taken approval from NCLT that one of the asset we will include as a going concern, second asset we will sell as an individual. So pros and cons were discussed. It was felt that third option could fetch the best possible, because Pantnagar we had a buyer separately to buy as a individual basis. So accordingly, the sale process was conducted, third with the third option, and NCLT approval was taken. So two registered valuers had, at that time, that 7 days clause was not there. So we could have appointed the valuers at any time. So again, we got the reserve price, that valuation done. आगे चलना और थोड़ा सा नीचे, हल्का सा नीचे. हाँ, so wherein आगे, yeah, पंतनगर का 52 crores BDO and GAA 37 crores, 44 was the this thing, the average value, and Nagpur 57 crores, थोड़ा सा नीचे, yeah, was the average value. आगे. Yeah, contingent arbitration proceedings also were valued for 17 crores. So thereupon advice was sought, reduce about the reduction in the price. So ICICI Bank reiterated the options and requested liquor price as status, operational capacity, आगे status of orders, या नीचे. So what is going on? Everything was discussed. Post considering, they said that the erstwhile buyer for Pantnagar plant, wherein liquidator paid no communication will happen, etc. Based on only Nagpur, आगे चलो, yeah. As we Jammu and Kashmir, third option for, yeah. Yes, कुछ देखते interesting अगर. So taking note of the above, like saying, SCC members putting assets collectively, and the liquidator we interested that buyer, for Pantnagar plant, 44 crore, looking to the response of the investor, so and so, so and so, so and so, SCC members reserve price of 50 crores. So reserve price was fixed as per the consultation with the SEC. So the way forward आगे थोड़ा सा नीचे, yeah, sale notice will be published and so newspapers in Maharashtra and so in Pan India, and date was fixed as all that was done. So fine. So this way, this way the sale happened, and later on again we sold it for I think 90 something crores because 10% was done reduction, not 25%. So accordingly, and later on again we saw auction notice, we can see, Saurabh. So as a going concern 73, then as a industrial plot of Pantnagar 38, then business as a going concern 41. So then contingent assets 11 crores. So some options were kept, So a person could have applied for any of that, kuch some things were done. So these all options were giving. So business also as a going concern was an option, So this way, and corporate debtor was also an option. So 73, when the corporate debtor, entire corporate debtor is being sold. So then Pantnagar, since that was out, 38 was the price for that. 41 is the only the business of the corporate debtor, not along with the land and building. So then contingent assets like the arbitrations 11 crores separately was also an option. So we have already written here, if lot number 1 is being opted, then this business and all would be withdrawn. The third and fourth lot will not be sold because the corporate debtor goes as a concern. So all this is included in that. Regarding Nagpur plant, land, machinery, etc., is there in the sale of CD as a going concern. Yeah. So options may be given, So separate options. So when we say like first option, since the CD is to be sold as a going concern, so that would be entirely for that. Second option onwards, you can also give an option that if somebody is interested to buy as a going concern, he can opt for the entire CD, or second option will be individual assets. So if we do not receive, then it's fine. As a going concern, then individual assets will be sold. But if that is received, then that would be given preference to sell as a going concern, and other lots will be cancelled. The sale will be cancelled. So only auction would happen like that. But in one of my matter, I did the inter se bidding for everything, and as per the SCC's direction, and we then saw that what was the which one was beneficial for them. So if individually we got after inter se bidding, better pricing, so that then they would have preferred that. So all this is as per the commercial wisdom of the stakeholders committee. So they may apply their commercial wisdom and give consultation accordingly. Then for the sale as a going concern, since the process involves lot of complexities, so a process information document is prepared, wherein we give all the terms and conditions which for the sale, So we will show you so that there is no confusion later on, and we can refer to this. इसको full page किया जा सकता है क्या सौरभ? नहीं होता ये हाँ, yes. So this would be better. And नीचे zoom का भी है थोड़ा सा option, second last. Yes, now it's better. Yes, so nice. So the purpose of this document is to lay out the process for submitting the e-auction bids for purchase of the corporate debtor, Messrs. Apex Bids in liquidation as a going concern in totality, along with its employees and workers, in accordance with the IBC code and the IBC regulations. So please note that the plant located in MIDC so and so Nagpur is operational and processing production is going on primarily job work basis, for therefore clients involved have lien over the material. So we clarified here, since we had given assurance to the clients that their material would be safe, so and they can take it back. So we have specifically mentioned in the process information document that they have a lien over the material supplied by them for processing for fabrication on job work basis, which may comprise of stock of raw materials, WIP inventory, finished goods inventory, and related scrap lying at Umred, so and so. Find attached the material list, detailed material status on ongoing order. So everything was given as an annexure and clarified itself in this document. So आगे चलते हैं थोड़ा सा. Yes. Yes. So they may do their own independent due diligence, all that. आगे. चलते जाओ, चलते जाओ, चलते जाओ. Yes, slowly, as is, where is always there. Whatever there is, this is without any recourse. Yes. Yeah. Statutory requirement, liquidate, except no liability, etc. is always there. These things. Physical visit may be conducted. So it's an indicative. Whatever is being given is indicative and not concrete. List of machineries, etc. So there may be some things available, not available, or whatever is there. So they may do their physical due diligence. So these are the information they shall read, and what all is the cost and prior dues and everything is mentioned here in the process information document. Yeah. Yes.
So I'll share the important information which is mentioned, which gives the overview of the corporate debtor and what all is operational and all. So I'll show that, sir.
Right. ऐसे धीरे धीरे चलते जाते हैं नीचे नीचे. या description. Yes. So everything is there. Physical verification. ये तो general है ही है सारा. So it's a huge detailed document, consisting of each and everything. So yes, next. Yeah, these are EMD, etc. So anything regarding the operations, one was regarding those material line. So forfeiture, etc. is there. Yeah, चलते जाते हैं. चलो 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 चलो, ये तो नॉर्मल चीजें सारा. Yes. So all this is there always, Yeah. नीचे चलते हैं. Yeah. So stamp duty, registration, etc., each and everything, statutory dues, assessment fees, all this everyone writes. Besides, MEDC has issued termination notices. And so all the information about the plant, the lessor, who is the lessor, what all the dues. So claims are there from in 8 crore 15 lakhs. So this all to be borne by the buyer itself, So and so and so termination notice was given for the lease deed for the where the plant was running. So this also has been informed. So electricity department, power load, etc. So shall be responsible, requisite approvals, etc. That is definitely their successful bidder has to do. So since it's a running concern, so many things need to be taken care. It's not only an asset which he may take and go. Yeah. Timetable for the auction. Aage. Yes. Little further. Yeah. Yes. 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 Mhm. And the details of each and every asset is being given. Yeah. Plant capacities, etc. What all is being manufactured, pre-engineering, buildings and structures. Fixed assets is the list is there, inventory, contingent assets. और आगे, yeah, later, factory land, this is there. ERA building systems, ERA builds the detailed landed property and letter confirm. Yeah, fetched from records. Yes, yes, we can go further. We can go further, sir. Yeah, these are the plant and machinery. Yes, we can go further. Yes. Stocks, etc. So these are basically the stocks are the tools which are lying there. Generally, the spare parts of the tools, etc., which are lying there, because the material stocks of the raw material, etc., that belongs to the buyers. So job work basis, we have separately given that, so that there is no confusion. Tata Blue Scope has given certain material, then these Dream Steel and Shapur Polanji. So all those is belongs to them. They have a lien on it, so they can end it. So this has to be clear there in the process information document. So it's an indicative list, etc. So copies of lease deeds, etc. So yes, all this is being given. The lease deed itself has been attached. All the notices, whatever has been received, the statutory dues notices and the past dues. Chalo. Sitcool, etc. is there. Further. Yeah, these are the issues. Notices by the authorities. So everything has been attached. The deeds itself. In case all this become part of the process information document. So rather than everyone coming and asking for, provide these document list of the arbitration cases, all this has been given along with the process information document, so that the person gets complete information in the first glance itself. So all this is there. Yeah. So that way, process information document ho gaya. So you can come back. So then what happens when the person buys the company as a going concern. So definitely, like a resolution plan, he has certain terms also which he needs to ink, so that later on it can help them if in running the business, and so a solution to the issues which may arise during the running of that business. So the buyer provided a term sheet along with their offer. So that term sheet will just show you how it was there, what they have. It's just like a resolution plan. थोड़ा सा बड़ा कर देना और थोड़ा सा हो जाए तो और yeah. So this is a term sheet which has been signed. Yeah. So this is the background. आगे चलो. So what all is there? This happened. This is the order. These things are there. Then e-auction, how it happened, what is the details. So how they bought and as is varies, etc. Sale as a going concern. So pursuant to the sale notice dated so and so, they have been declared successful. Terms of acquisition. These are the terms. So while its order has been conducting liquidation, pertains as so and so auction purchaser and has purchased the company and unless the context auction purchaser so and so, these are the terminology being used. आगे चलते हैं या definitions देख लेते हैं, cut off date etc. आगे या in any case we will issue certificate of sale. So for the sale as a going concern. So binding terms, the cutoff date and determination so and so, the auction purchaser already made so and so. Then confirmation of sale issuance pay, he has to make further payment so and so. So 30 days, then 90 days, this all is to be paid, balance amount along with the interest till date of payment. Sale shall result, shall result in the transfer of the entire available assets. So of the corporate debtor in favor of the successor, all assets and liabilities without any further act or deed shall become assets and liabilities of the option purchaser as on closing date. Any distribution of the sale consideration received shall be governed by 53, subject to applicable laws due to payment of full consideration, all statutory approvals, permissions, so and so, quotas, etc., exclusively relating to corporate debtor shall stand transferred to the auction purchaser. See, he may need, these licenses and all that are in his name. So all these, he can use all the brands, etc., everything. Then the liquidator shall deliver and hand over physical delivery of the plant, machinery, equipment, other assets to the buyer, auction purchaser. And the liquidator shall provide to the auction purchaser originals or copies of the records pertaining to the corporate debtor upon receipt of the entire equity of the equity of the corporate debtor is proposed to be transferred to the auction purchaser. So it was a transfer of equity. So the transfer of ownership shall take place by way of writing of the entire existing also. So it was writing of the equity and issuance of fresh equity shares. So the share shall be issued but only in the name of auction purchaser and will not be issued in any other name. So that 29A compliance is there, So full payment of the sale consideration amount existing board of directors will cease to exist. It's already ceases. So as I have told you, the board of directors is terminated. So auction purchaser after acquisition shall constitute a new board of directors, which will consist of its nominees. Upon full payment of the consideration, all assets of the company shall vest in the purchaser so and so will be available to the purchaser for use without any authority. All asset security guarantee in the liquidation, whether in favor of lenders or in favor of shall stand released or extinguished. So automatically, all the rights or encumbrances of the financial creditors, etc., shall stand released or extinguished. So this is to give confidence to the buyer, And this term sheet was got approved by the SCC also. So in term sheet, the parties hereby agree and the closing date, profit, losses, as well as risk, etc., shall be deemed to the profit, losses and of the auction purchaser and shall be transferred to the purchaser, auction purchaser upon payment of sale consideration, upon full consideration. All financial creditors, other creditors shall file satisfaction of charges in the MCA portal and CERSAI, CIBIL, etc. So all known, because in CIBIL, the corporate debtor shall have been depicted as a defaulter. So this need to be cleared, all these things by the financial creditors. So all known or unclaimed, unknown liabilities, etc., on this cutoff date, all secure prior claims of creditors, statutory authorities, taxation, transaction on account of transactions of before credit shall be dealt as per the provisions of law. नीचे ठीक है, नीचे रखो, कोई बात नहीं. Shall be dealt as per 53 and full and final settlement of the dues. The liquidator shall in no event be responsible for any obligations risk pertaining to the period prior to the cutoff date, and same shall be dealt as per provisions of law and NCLT's directions. all liabilities but not limited to the employees, workmen's related liabilities, provident fund, ESI, retirement shall be to the account of auction purchaser, including liabilities accruing post-auction date. So if anybody is discharged or retires or resigns, all those things, terminal benefits, he'll take care. The closing date of the transaction shall be 90 days, and for within 90 days, all auxiliary processes at present time sheet shall be executed, implemented. The said executions include but not restricted to distribution of the purchase to consideration to the stakeholders, extinguishment of shares, and issuance of fresh shares. So all this will be done within 90 days. And as on commencement date, all the outstanding negotiable instrument issued by the corporate shall stand terminated or extinguished. No liability shall arise. Yeah. So 32A, which gives protection to the auction purchaser, shall be there for the auction purchaser. So he is depending on that section also. So has been inserted wherein he is not responsible for any offense committed prior to the commencement of CRP, and auction purchaser satisfied the conditions stipulated 32A. Therefore, auction purchaser will be granted immunity from the liability. So these are give satisfaction to the purchaser also, before CRP date if anything has happened. So he shall issue such receipts as the liquidator may require. Yeah. चलो आगे चलते रहते हैं. So, बाकी की तो normal चीजें. So these were some specific things, in the term sheet, relevant things, चलिए. Then another unit which we have sold was this thing, Max Mobile. So the buyer decided to go to the NCLT and obtain order on the term sheet. So NCLT avoided its order dated 21/8, gave this order. You can see.
First, we can show the liquidation order wherein the discharge is mentioned.
Acha. Okay, in this case specifically, order was obtained for discharge of the employees because he wanted to employ fresh workmen and employees, So therefore, terminal benefits claim was also taken. So in the order itself, discharge is there, discharge of the employees, because the CUC had decided and that it's not viable to continue the workmen and employees. See, here, liquidation shall be deemed to be notice of discharge to the workmen employees, except to the extent business of the corporate continued during the process. So they say ki, if he requires, liquidator requires some of the workmen or employees, those will be retained, which are required for the business whatsoever during the liquidation process. All other employees shall be discharged. So this order may be also prayed for, by the liquidator. So moratorium is definitely there. So this was a different, exceptional order. So wherein discharge were also being prayed for. So accordingly, we discharged some of the employees. These are all concerned to this order. So whosoever were to be returned have been communicated separately. So they may, obtain their workmen employees, their experience letters, etc., discharge letters from the HR. So such a way, discharge was given, and workmen employees were discharged on the liquidation. So in this scenario, they will raise a claim for their terminal benefits. So in the LCD, on LCD. So intimation letters were also sent to the statutory authorities about the liquidation process that it has been conducted. So it is required by certain laws, Income Tax Act requires, Sales Tax Act also requires the liquidator to inform about the liquidation. So accordingly, this all was informed, So it was also told that as a going concern, so and so it has been liquidated. So this way. Then is term sheet. Again, here also term sheet is there. So the buyer gave such term sheet. Tushti is the buyer. दिखाना थोड़ा सा, हाँ, बड़ा कर दो. तो आगे चलते हैं. Yeah. देखो कहाँ काम का शेयर होल्डिंग है, जहाँ पे नाम दिए हैं शेयर होल्डर्स के, यस. So this way, shareholders name was given. So these are the existing shareholders. Yeah, these were the existing shareholders. चलते आगे. Then restructuring. The consent may be obtained and provided by the ex-directors promoters for the change of the shareholders to so that we can transfer their share. So here they have not extinguished but transferred. So the directors, the present shareholders also transfer there, as we are not intending to continue any old relationships. So and so, fine, the existing share equity is proposed to be transferred. So they have transferred the existing equity. So all the shares were transferred to the new shareholders. So that, by order of the NCLT, it could also happen that way. So they had an experience in electronics, so they would do the efforts for completing the projects, etc. So they have given an offer for 33 crores EMD deposited. So ex-promoter directors give consent that no pending litigation in relation to the no future litigation shall be taken up. The balance 90%. So these are certain demands which we definitely these are by the buyer but were not agreed upon. So we have not there the consensual term sheet was there. Here the buyer has given their term sheet and said that he wants so and so things to happen, by the authorities and all. So this is the wish list of the buyer. So this wish list was just taken by us, not accepted, in entirety. It was put up before NCLT. We'll come to that. So all this like a resolution plan, but later on, finally, it was definitely got mentioned from him that this is all is not a condition. An unconditional offer is there. 32A is here also, and he may reorganize the staff. Treatment of related party claims is there. Then sale of properties, part of the properties he can conduct. Bank guarantees, what will happen? All this is mentioned. Water supply requirement, pollution control, electricity dues waiver, ability to use can send wet credit, service tax. Then issuance of permission letters, approvals required for operation, grace period to comply, future statutory regulatory requirements, whatever was delayed compliances earlier, extinguish of the existing onerous contracts by the corporate debtor. See, there may be certain contracts which the buyer may not be interested. So termination of existing negotiable instruments, revocation of power of attorneys, waiver exception. So waiver of valuation of pricing of shares by registered valuer, liabilities that may accrue under various corporate laws, rules and regulations. So though all this is being given, but it will only to the extent, which is allowed by the various laws, it would be carried out, sections of income tax, MAT, etc. So then carried forward losses, then claims by government authorities, all this is there. So what will happen to that? So all this is there in the term sheet. Because going concern is, very different from sale as an asset. There may be hundreds of issues involved, contingent liabilities, operational liabilities. So waivers of various taxations, etc. Chalte hain. Yeah. So many things, disqualification, preferential transactions, what is to be done. So all this is there. Carried forward of losses is there. Assets of the corporate debtor. He assumes that all the term sheets are mentioned, etc. There, and then encumbrances, etc. may be removed. Compliance is suspended immediately. The corporate debtor, the existing director shall cease to be directors. In any case, by liquidation order, they cease to be existing. Legal proceedings, etc. All inquiries, whether civil or criminal. litigation shall be withdrawn, no due certificates, then by the creditors, then general covenants, the deed shall be signed simultaneously, etc. Legal cases, yeah. Balance sheet of the corporate debtors, they may ask for, reconstructed balance sheet. So as on the transfer date, so that, all the liabilities are wiped off and there is only the assets and whatever they have contributed. So he is asking, so however, everything will be carried on as per law. So old liabilities, yes, it shall be confirmed that all liabilities shall be. So these are all wish list. आगे चलो, yeah, owned by Max Mobile. Balance sheet shall be audited on cut-off date, etc. Acceptance shall be conveyed to clarification, etc. And so and so, so and so. Yeah. So this is the term sheet which was given, and we took a legal opinion on it. This is a legal opinion. Term sheet dated so and so, read by, it is customary to independent opinion. Conclusion देख लेते हैं basically तो. So each and every aspect, has been examined by a legal expert, so that there may not be any issues. So we have taken for each and not applicable so and so, provided nothing and exemption so and so. However, provisions that nothing contains shall apply to a company. Other laws, other laws, payment of stamp duty, other compliances so and so so and so. Filing. So each and every aspect is being covered. So whatever is being asked, as the following procedure shall be transferred of share and acquirer to make application and transfer so and so, then a confirmation letter in favor of the post disbursement of consideration amount, and letter to be confirmation letter to by the liquidator for transfer from so and so, confirmation letter to be issued by liquidator for cancellation of share certificates held by shareholders to make update. A liquidator issued new shares. However, moreover, so since whatever they have mentioned, we took the legal opinion and acted upon that. But since we have to see the provisions of law and what all can be done, what all is restricted. So this is MGT 14, etc. And so documents are to be attached. So all this was carried on accordingly. Filing of CHG 4, yeah, definitely required satisfaction. आगे चलो. यहाँ आगे 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 ये तो फाइनेंशियल कैरेक्टर्स का हो ही गया नॉर्मली उसके साथ. Other compliances, payment of stamp duty. So everything that said stamp duty is to be paid, CD being into liquidation, electronic is not feasible, demat of security held in physical form is to be done. So mandatory, therefore, they said provision would be not be applicable for entire transfer. Shareholding is transferred to a wholly owned subsidiary or through nominees. Updation of statutory records, other compliances, yes, of Companies Act, etc. SEBI, income tax, आगे चलते हैं. हाँ. Income tax act, so and so provisions, so and so things are there. आगे. Yes. Other laws, चलो. Yeah. So all this is there. So each and everything, So each and everything was there, where opinion was taken, and an application was also filed with NCLT. that this has been received. So we filed an application that this term sheet is there. So like a resolution plan, so because it was a new process, we were also not that much aware. So what is to be done? So we went to NCLT to take directions from NCLT. So these were the prayers: issue appropriate directions for approval of term sheets. So and so committee of approved by the stakeholder committee in liquidation proceeding because after the legal opinion, the revised term sheet was obtained as per the legal opinion, that what all we could do, what all we could not do. Then consequentially grant the relief and concessions that were sought, like a resolution plan. So they had certain reliefs and concession, but though they were not conditional. So accordingly, we filed this application. So now we'll show you the order, which was passed by the adjudicating authority. This is the order passed on this. So final उस पे आ जाते हैं, conclusion. Yeah. Yes. So held से और ऊपर held, heard the concern. No. Yes, यही है. Heard the liquidator after an elaborate नीचे ही है. Yes. After an elaborate argument, counsel for liquidator seeks to withdraw this application. Since the NCLT then directed that it is not required, that approval is not required. However, they said after withdrawal, they made it clear that if the auction purchaser confronts any problem with any authority in respect of the sale of the CD as a going concern, it would be at liberty to approach this tribunal for redressal. So this way, order was passed that approval of term sheet is not required. So though even term sheet is not required, but however, if they face any issues, they can come to the tribunal. So then a sale certificate was issued, which is as per the law. So this is the sale certificate. Yeah. Yes. Yes, put into the auction, so and so as a going concern as sold on behalf of maximum. The undersigned acknowledge receipt. आगे highest bid in the e-auction. Yes, नीचे. So the sale of as a going concern was made in terms of e-process document. The liabilities shall be dealt as per provision of 53, immunity provided under 32A regarding attachment and proceedings, and the liabilities will be available to the auction purchaser. This is for the confidence of the buyer. So accordingly, the sale was concluded. So these are the two sales. Now going further. So see, then how we hand over this going concern to the buyer, because going concern has many things which may need to be addressed. So handover letter is elaborate. So can we show it? Yeah, बड़ा कर दो थोड़ा सा, और हो सकता है थोड़ा सा. So and so. Here the following stands fulfilled by virtue of operation of laws: extinguishment of entire shareholding which was held. As per the request, then transfer of the entire remaining shareholding of the so and so and other persons as proposed. So and so. Cancellation of share certificates held by the existing shareholders promoters, issuance of new share certificates in favor of Tushti as provided by so and so, reconstitution of new board constituting the directors nominated by your good self and per proposed list of directors. So simultaneously termination of existing directors of the company. In view of the above, undersigned request to intimate registrar of companies of the aforesaid changes by filing requisite e-forms. So this is how the company, the corporate debtor, is being handed over. Yeah. Then possession letter for the assets, of the corporate debtor was issued. Yeah. So herein we have taken a possession receipt, so that we shall be later on be safeguarded from any kind of litigations. That I have found all the assets in order, I have inspected it, and there is nothing is pending from the liquidator regarding this assets. So description of the property for each and every asset separately, this kind of letter is taken. Acknowledgement has been taken from the buyer. और नीचे क्या है? सौरभ नीचे है कुछ?
Sir, it is for all assets.
Other assets separately.
Yes, other
Okay.
assets separately.
So all the assets, all these possession letters separately for all the assets. ठीक है. Yes. Then is public announcement. Yes, this is another safeguard, so that that the company has been sold for to give a public information and to all stakeholders and other public members. So this has been said that in this way, extinguishment of shareholding has been done, transfer of this shareholding has also been done, and the proceeds have been distributed as per 53. So now it's so all the rights, by liabilities and rights or interest of stakeholder stand settled or extinguished as the case may be, without any recourse with the stakeholder in any form whatsoever to Messrs. Tushri International. So this way, public announcement has been given. So these things gain, confidence of the stakeholder, because he's buying as a going concern. So there may be certain claims later on. So these gives confidence that yes, so we may fetch better value. So this is for value maximization, we may say. So this is the share transfer letter. So if there is a transfer of shareholding, so it is given accordingly. Transfer of the shares in our term sheet we had provided for 100 so kindly transfer Indian held by all Indian resident companies in favor of Tushri, and it is also emphasized among the all erstwhile there is a company named Star Asia Singapore holding so and so. The company based as however requires to extinguish. So so that there is no issues regarding FEMA etc. आगे चलो. So accordingly, we request you to transfer the shares, all that is there. No dues certificate was obtained from the lenders. So this way, these are the no dues certificates. SBI, that release of the corporate guarantees given by Max Mobile, corporate guarantees have been released. That yes, आगे notwithstanding any of the remedies against so and so. So all the corporate guarantees, assets have been released, no dues has been given. Then RBI has been intimated about the transfer. Yeah, थोड़ा बड़ा कर देना. Chief General Manager as also intimation tribunal order under the provision the company received investment because there was a foreign investment. So RBI has also been informed. Right of the investment of so and so, extinguishment of shareholding by the investor. So such write-off do not involve any repatriation. So since there no money was repatriated to the outside India, so this has also been communicated. आगे थोड़ा सा नीचे, yeah, yes, थोड़ा सा नीचे, yeah. Your attention is 238. All the provisions of IBC will override over all other laws. So this way RBI नीचे भी है वैसे हमने SEBI and all those other things. Everyone has been informed about this. Yeah. So these are the annexures. Okay. Then share certificates. New share certificates have been issued. though this may be done by the board of directors after reconstitution. So, however, here, split shares in way of cancellation of certificate number so and so, equity shares of so and so have been issued, number of share held, like that, Aage. Yeah, this is the certificate. Then full and final handover. After doing everything, so herein, yeah, see, to Tushti International, full and final handover pursuant to its sale in pursuance of has been entirely sold and so, that we have filed INC 28, which is for changing of the status of the company and also about the going concern sale. Then, following intimations have been given, all the EPFO, etc., taxation authorities, SIPs, and special economic zones. Yeah, and no dues have been issued, and so have been remaining. So you may follow up with them later on. Then sale proceeds have been distributed, and satisfaction of charges have been requested. So and rentals, there were certain properties which were rented, so tenants have been intimated about the sale, and they are being requested to pay rentals to your company. So then is then a possession has been handed over. Each and everything, whatever has been done, so is in implementation of that term sheet or in implementation of the sale as a going concern. Then discontinued the security agency, ROC MGT 7, AOC 4, DPT 3, ADT 1, MGT 14 have been filed along with GNL 2, because the liquidator can file the documents in form GNL 2. So accordingly it was done, and secretarial audit, etc. And each and everything has been given as a going concern, and all the compliance is done, RBI intimated, extinguishment of shareholding, etc. And this thing, transfer of shares done, entire shareholding, and so memorandum of transfer, then newspaper advertisement, then title deeds have been given, insurance of the company's vehicles, then GST of the company restored, and filed the GST TDS returns, SCZ, property assets. These are to be done for any going concern. So attachments, etc., with respect to have been mailed. So we have requested for extinguishment for attachments. They will. So we have got removed by NCLT also certain attachments. So NCLT orders were have been mailed. So avoidance application are there. So filed condonation for filing of avoidance application. Then so and so sent tally data, audited balance sheets. These are for ITRs, etc., user IDs, passwords of the portals, since it's a going concern, accounting software. Then the status has been changed again. In IBBI, IBBI was requested. Actually, this was a contentious issue for changing the status under CRP to changing active company. So IBBI, MCA, all were requested. So it was. I don't think it was done. Later on also. So we followed up. So, but there some procedures need to be devised, that automatically when a form is filed for change of status, it must be done to the active company. So since the form is not there, we have already filed a request letter. So they were requested to follow up the same. Chalo. So this is about the handover of a going concern. So, there are certain during liquidation hostile situations also. So like in my matter of Moser Beer, so there were 2,300 workers which were working. So these need to be handled with great, care and diligence, so that there are no untoward incidents. Because before I was appointed directly as a liquidator, so before that, in CRP period, there were suicide attempts. Even there were protests in the open streets and before the district magistrate. All these things were there. So these needs to be diligently and carefully handled. So that I've already explained you. You need to build in confidence with the workmen. You need to keep them informed of each and every development. In our another matter, this Max Mobile itself, even the representative of liquidator, he was detained by the workers employees. He was out there for a long time. That was published into newspapers also. Can we show, Saurabh, that Max Mobile ka? Yeah. So see. So he was held hostage. Yeah. A person was held hostage. Aage, next picture. This way. Yeah. However, we took them into confidence and, very cordially, the situation was handled. We arranged for food, for the workman employees, so that though they were holding a person as hostage, so food was, arranged for them. Everything was cordially handled. So this is the way, if we are also agitated, or if the situation is, tried to be controlled by way of, authority, that may create issues. That may be, that may expand, enhance the difficulty. So always with workmen, employees, etc., it should be carefully followed. There may be some people, like in one of my matter, which is recently going on. What I have done is, instead of removing a person, because that person was a kind of a leader, so he was creating issues every in day-to-day working. So instead of removing that person, better is, I told him to not to come. He will be paid his salaries and he may work from home. That will be a better situation, because if he such kind of a worker, he comes to the work, he may obstruct the others working. So calmly and with a great mental balancing, the situations need to be handled with the workman force and all these things. So going concern, keeping the CD as a going concern in during liquidation also, though similar to what is being done in CRP. I have told you all the four differences. So, but since the the major difference is that there is more skepticism about its existence. The stakeholders, maybe the workmen, the clients, or the authorities, all are always, under an dilemma situation, wherein they may you be suspicious about the closure at any time, because liquidation itself, the word liquidation itself, tantamounts to a closure. So as we all have heard since our since the beginning, that liquidation, the companies under liquidation means it is a closed unit, and it is being dissolved, assets will be sold. Though under IBC, this is a unique proposition that during liquidation also the CD to be kept as a going concern. But for liquidator, the things are little more difficult, I should say, than which were under the RP, because RP has the directors with him. RP has the confidence of resolution amongst the stakeholders, that yes, there may be some revival. But in liquidation, since there being more closure situation, I should say, the situation being close to the point wherein the any day the company may be closed. So the stakeholders may not be very confident, and then the liquidator has to be more balanced, has to be more tactful in handling. So he has to, definitely convince the clients to get orders. He getting credit also, getting credit from the clients, during liquidation period. That from the raw material suppliers or transporters or anybody, that may also be an issue. So for that, it will all be upon the credibility and the tactful handling of the liquidator, that he may be able to run the unit by giving confidence that yes, they will be paid, and by giving assurances. And that would definitely require more involvement of the stakeholders like creditors, basically the lenders. Because if you have certain supplier who's a very big supplier and very crucial for you, I would propose even you can take such a person to the stakeholders committee meeting, and so that if he gets confidence from the lenders, yes, definitely, that your interest would be kept in interest, and we will endeavor to sell it as a going concern itself, so that some other management comes, so your business is not hampered, our value maximization is also there, and your money remains safe. And when the lenders give such a confidence, that would be more effective. So liquidator has to balance between the all the stakeholders, including clients, including lenders, including suppliers, and the workmen employees. So during liquidation, keeping as a going concern would entail more tactfulness. That is the crux of everything, So the entire presentation. Saurabh, आगे कुछ है? Yes, this may also be happen, and this generally happens during liquidation. What happens is, till now, all the investigating authorities have been activated, and the bankers, the lenders, they may have also filed some criminal complaints, etc. So there may be raids, and in most of my matters, it has happened. In Mozarbeer, it was quite publicized also. So then they require your physical presence, and from time to time you will get summons. So what I do is, see, I tell them, regarding physical presence, definitely I would send some counsel or advocate or representative. We generally, during liquidation also, even if it is not a going concern, or like I informed you during filing of application, we discharge all employees, but maintained certain employees which were required. So some of the persons of corporate debtor, important persons, should be continued. Even in as a going concern, we don't need much of the persons, and if we maintain some people, what we can do is, during the raids and all these kinds of investigations, those persons may come to an aid. They can provide information to the investigating authorities. And what I do is, if some documents are asked and I do not have any person or employees, what we can do is, we do write to them, to the ED or the CBI, that we as a liquidator are custodian of records. We do not have people, so we can provide you access to the records. All the required documents may be taken out from that. We are maintaining the documents with or records with certain that documents record management company. So we give them access to that place, so they may visit there and get whatever documents by themselves if we do not have some persons. So in this Mozarbeer matter, ED summons, they issue by WhatsApp. They would say you immediately, within an hour, you need to come. Then you have to tactfully tell them, because you may be involved in certain things. So that way, it in this case also, what happened is, court is writing like your name as an accused, because you are the liquidator. So in this case, they had written, Anil Kohli, Liquidator, Moser Bear India Limited, like that, and accused. So we got that someone amended by order that only that company should be mentioned, not the liquidator. See, the accused is Anil Kohli for Moser Bear. So it should be Moser Bear represented by the liquidator. So that may be there. So it was got amended by the court order. Otherwise, you may have issues later on. So these kinds of things definitely happen. So these raids and these will definitely, almost in all the cases it comes. Income tax though definitely is there, and so income tax authorities, you need to handle their investigation and provide them all the information. So better would be to retain one or two employees of the companies who are having all the information and everything about the affairs or the conduct of the business of the CD. So that would definitely come to your aid. So even if like Max Mobile, you take a discharge order for employees as a going concern, but so now is the discussion paper. So I would just read out the proposed amendments in the discussion paper. So these will be definitely very helpful, and these may definitely come to your aid. So here they say, हम going concern वाले ही करते हैं यहाँ पे सौरभ, बाकी सारी तो सब लोग पढ़ ही लेंगे. So there, the timeline should be increased. These are the proposals which we have given. So we have asked them for increase in timelines, and they have said that private sale, that the private sale you cannot do without approval of adjudicating authority. That will increase burden. So we have requested that if the SCC advise, and that to be mandatory is inserted, that would be better proposition. Aage. So for attachments, etc., for publicity, some photographs of assets, QR code may be there. Aage chalo. Yeah, sharing of reports with directors, etc., maybe which is being proposed here may become a little contentious, may rise litigations. Then fee calculation, we have proposed that it should not be from liquidation commencement date, but better from the date of filing preliminary report, because the effective steps are taken after for sale after preliminary report only. So certain things, meetings every 30 days, SCC meeting, that may be a time consuming process, and for even for the creditors it may be difficult. So stakeholders committee, they say should approve the report first. So that approval may be very difficult. So we say even if they don't give any suggestions, the timeline should be met, because otherwise liquidator may be in dilemma. So this way, we concur with certain proposals. Aage chalo. Liquidation cost, etc. So fresh valuation of assets, they say. So that valuer should give their basis of valuation. So avoidance applications. So they say continuation of proceedings. They say should be continuation of proceedings should also be approved by SCC. So there may be taxation authorities who may not opt for that, or even directors, promoters are there, shareholders. So they may also not approve the avoidance application. So this may make things be difficult for the regulator. So this should be avoided. So here they say regarding, so this is the proposal 12. In the event the business of the CD is running of the business is economically unviable, the liquidator shall consult the SCC to decide whether to keep the CD as a going concern or otherwise. In case the SCC decides not to run the business of the CD as a going concern, the liquidator shall act as per the advice of the SCC. So here that exception, otherwise the advice of SCC is not binding. But here, if the SCC says that the CD's business shall not be kept as a going concern, then the liquidator has to act. So mandatorily they have, first time it has been given that the advice of the SEC will be mandatory regarding the going concern. So where the liquidator is unable to sell the CD as a going concern through business of the CD is running as a going concern, he shall inform the reason for such failure to SEC and seek advice to review the marketing strategy already adopted for previous auctions to attract potential bidders in future auctions. Definitely marketing strategy we do discuss, and all the liquidators will definitely try to do whatever best possible, So this way, yeah, आगे चलो. So Form H, they have said, then avoidance litigation shall be, Regulation 38, because for closure of proceedings, we say Regulation 38 shall be mandatory. So, and avoidance and litigation should be included. Because, Regulation 38 is about distribution of unsold assets. Sometimes what happens is avoidance, due to avoidance or litigation, we are not able to file dissolution application. So it should be made mandatory because lenders hesitate to take over the litigations or avoidance. So that's why we have proposed that avoidance and litigation should be part of the unsold assets in Regulation 38 and should be covered by 38, and which should be made mandatory so that dissolution can be done timely. Yeah. So then 2 years should be given for liquidation process as was earlier, because unnecessarily we are going for extension application and everything. So that's it. So, and should not be discharged, therefore claim or terminal benefits we have already said. So costs incurred in business as a during liquidation should be net of the revenue only. So they say ki, there is a proposal which is coming up that the running of business of the CD as a going concern during liquidation, the cost should be the cost incurred on that would be liquidation cost. But we are saying that it should be net of the revenue earned. So if there is a deficiency and the cost is not totally met, so the balance out which is not met, unpaid cost, that only should be taken as a liquidation cost, not the entire cost. Like in CRP, the entire business running cost is treated as CRP cost, though in my view only the unpaid cost or the deficiency should be the CRP cost. So whatever revenue is there, or even the as debtors are there for the CRP period, they should also be netted, and the CRP cost should be only whatever is unpaid, opposed to giving credit to the revenue earned or the debtors their outstanding. Only the balance should be CRP cost. Otherwise, there is a, in my matter itself, there is a litigation going on. So that that the RA is saying that the unpaid creditor for the CRP period is CRP cost. So that should be paid. So I say no, there are certain debtors also for the CRP period. So that should be netted, and only the deficiency should be the CRP cost, because the debtors have been realized by the RA. So he shall pay out of that debtors to the creditor, and the net of the same should be the CRP cost, and will be payable by the RP post implementation of plan. So that litigation is still pending under adjudication. So we'll see what comes out. So as a going concern, there are certain landmark cases. One is Swiss Ribbons, wherein the Supreme Court has said that what is interesting to note is that the preamble does not in any manner refer to liquidation, which is only availed as a last resort. If there is no proper resolution plan or plan submitted are not up to the mark. Even in liquidation, the liquidator can sell the business of the corporate debtor as a going concern. It can thus be seen that the primary focus of the legislation is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from a corporate debt by the liquidation. So Supreme Court is also insisting that there should be revival, and going concern or during liquidation should be promoted. So in KN Rajakumar versus V Nagarajan, Supreme Court has said, it could thus be seen that one of the principal objects of the IBC is providing for revival of the corporate debtor and to make it a going concern. Every attempt has to be made to revive the concern and make it a going concern, liquidation being the last resort. So everywhere, going concern is being encouraged during liquidation also. Yeah, next. In First Globe versus IBRCL, so more than 1,400 crores were owed to financial character since resolution plans were not accepted due to delayed submission and deviation in the EFT. NCLT has ordered that companies should be sold as a going concern. Same, happens in Apex also. So then Bharti Defense Matter. So by NCLT Mumbai has held that ultimate objective plan is to sell the company. Then it can be achieved by allowing the sale as a going concern during liquidation process. So all the legal forums, all the courts are also towards selling, keeping the company as a going concern, even during liquidation. So whether there is any bar in selling the corporate debtor after the first auction, and whether the liquidator is required to seek any promotion for such a sale. So Honorable NCLT in Delhi in matter of Sonu Trading versus Nosler has held that from the conjoint reading of 32A and 32E, it can be inferred that the corporate debtor can be sold as a going concern in the first auction. However, as regards to word exclusively mentioned in the 32A, we are of the view that whereas the corporate debtor may sell the assets of corporate debtor under clause E of exclusively only at the, we find no such bar in selling the assets of the corporate debtor in subsequent auctions where the liquidator has all other options of sale as stipulated under 32A available, including selling as a going concern. So not only in the going concern, so this concept was cleared in our mind also by this order, because exclusively only likha tha, so we were of the view that only in the first sale a company could be sold as going concern. But this order has clarified that no, in going concern sale can also be post this, first sale, first auction. So regulation 32 of Insolvency and Bankruptcy Code regulations itself provides requisite flexibility in choosing the methods of sale during the auction subsequent to the first auction. There being no requirement in law for seeking permission of adjudicating authority, we are not inclined to grant prayer of the liquidator. So no requirement of adjudicating authority's permission. So for sale as a going concern. So clean slate of sale or as a going concern during liquidation. For this, NCLAS has held in Shiv Shakti Interglobe versus KTC Foods that it has settled that when the sale proceeds of corporate debtor are duly distributed in order of priority and in manner prescribed under 53 of the code, claims of any other creditor cannot be entertained contrary to the provisions entailed in 53 subsequent to the distribution of sale proceeds under 53. No other entity, including government, can claim any past unpaid or outstanding dues against the appellant who has purchased the corporate debtor as a going concern. At this stage, subsequent to the sale of the CD as a going concern, these claims cannot be foisted upon the appellant. The scope and objective of the code is to extinguish all claims, specifically the ones which were not even made during CRP or liquidation, to aid the purchaser of the company as a going concern to start on a clean slate. Further, a tribunal held that it is no longer res integra that while approving a corporate debtor sale as a going concern in liquidation proceeding without its resolution in terms of regulation 32A or E of the liquidation process, it is essential to see that corporate debtor is not burdened by any past or remaining unpaid outstanding liabilities prior to the sale of the company as a going concern after payment of the sale proceed distributed in accordance with 53. Very nice order. So it has very much clarified that no liability will come upon the purchaser. And the Honorable Supreme Court in Ghanshyam Mishra versus Edelweiss and in SR Steel matter has laid down the proposition that purchaser of the company, even in liquidation, cannot be burdened with past liabilities when it is not mentioned in the sale notice. Yes. So 29A is applicable. So definitely. So the movable of the by public auction with transfer or same in such manner may be specified, may not sell the person who is not eligible as a resolution applicant. So 29A due diligence has to be done. So no person who is not disqualified under 29A can be taken. In Anand Kumar Jagatramaka versus Jindal Steel, Supreme Court has held that three modes in which revival is contemplated. The first of those modes is revival by under CRP. Second mode is when business is sold under 32E or F regulation and under in liquidation. And third is 230 of the code, compromise or arrangement. So further court held that the stages of submitting a resolution plan, selling the assets and liquidation, and selling the company as a going concern all indicate that the promoter or those in management must not be allowed a backdoor entry in the company and hence are ineligible to participate during this stage. So this is all. So we have kept 15 minutes in the end for questions or clarifications. So I hope I could put some light in this topic. So I would request everyone to please come forward if there are any questions. You may switch on the mic if you have anything to ask. Very surprising. So it was.
Sir, I am Minita Raja.
Yeah.
Sir, I have one question. Like,
Please.
while the company is into CIP and the company is like.
Sorry, your voice is not coming.
Project, right? So there are no activities.
Can you please
Now
come?
I'm audible?
Yes, now okay.
My question is like during the CIRP, there is no activity per se in the company. And then
Yeah.
when it is going into liquidation, the financial creditors decided to sell it on the going concern basis. So in that event, per se, the assets along with its licenses will be transferred as going concern, and the company will then be dissolved. Whatever assets or whatever is left after selling of the company into going concern. Is my understanding clear on this part, sir?
See, when the company is sold as a going concern, all the assets of the company, along with the company per se itself, is transferred. So then there will not be any dissolution. So it will be company will be transferred and final report will be filed. No dissolution will happen.
But if the COC decides that part of the assets would be sold off as a going concern.
See, even when part of assets are sold, some assets will be sold individually and the company itself will be sold as a going concern along with some part of the assets. Maybe like I told you in Apex Builds, we sold the company along with its plant at Nagpur as a going concern, and Pantnagar assets were sold individually. So in any case, when the sale is under going concern as a going concern, then the company would be transferred to the auction purchaser. So there will not be any dissolution in that scenario also, even if a part is sold as a going concern along with the going concern company. So going concern sale means company will be transferred. Even if with some assets, other assets will be sold individually and sale certificate will be issued by the liquidator for those assets. So these will be sold individually, which are kept outside the sale. But in any case, company will be sold as a going concern along with the business licenses or maybe some assets. So
Irrespective of the fact whether during CRP it's a stalled project.
yes. So
Oh,
Max Mobile was a stalled project, but we took the order for discharge of some of the employees, and the company was sold as a going concern along with all its assets. Though it may be some of the assets and some may be sold individually, as was done in Apex. But in any case, in a going concern sale, company will be transferred to the auction purchaser. No dissolution will happen.
right, sir. Thank you, sir. Thanks a lot.
Right. So, anything else? So I think everyone is clear, and I hope I have been, clarified some of your doubts. So for anything else, you can contact me. IPA has my contact. So, madam, from IPA, madam.
Yes, sir.
Yeah. So I think I have finished my presentation.
Okay, anybody, do you want to ask any questions?
If any questions are there, please.
Thank you, Ji, Diwan Saab. Thank you.
Thank you so much, sir, for such an informative session. We look forward for more sessions with you.
Thank you very much. Thank you, everyone, for being such a patient listener, and giving me confidence that yes, there were no questions left, and I was able to clarify all your doubts. So I'm grateful to everyone. Thank you very much. So I'm always available for.
Sir,
any
you are requested to share your PPT, please.
I will share it with the IPA. So anything still left, you can even contact me. My website is also there. So I'll share it definitely. So I'll try to share the draft term sheet along with the PPT. So as is being mentioned in some of the chats. So we'll do our level best. We are always with you. Thank you very much. Thanks a lot. Thank you. Sure. We'll share the PPT with the IPA.
Okay, sir.
Okay, grateful. Thank you.
Now there is lunch break till 1:30. Bhrugesh, shall we start?
Yes, we can start.
Good afternoon, all. Now the second session will be taken by Bhrugesh Amin, sir. Bhrugesh Amin, sir, is partner with business restructuring practice. He is insolvency professional and qualified chartered accountant. He operates out of Mumbai office and has over 16 years of work experience in banking and finance and business restructuring, manufacturing, EPC, real estate, and shipbuilding. His functional expertise includes business restructuring, operational turnaround, interim management, trust funding, and post-deal integration support. Now, so you can start the session.
Yeah, sure. Thank you, ma'am, for the brief introduction. And I thank you all participants for joining me on this session, as well as ICSI IPA for inviting for this session. I'll just share my screen, just confirm if anyone can confirm that whether the screen is visible or not. My screen is visible?
No, sir.
Not yet, sir.
Just. Now it is visible?
No, sir. It's okay now.
Oh, great. Thank you. Thank you for the confirmation. So, yeah. So today's session, the topic which has been given to me is handling corporate debtors under going concern during CRP. So again, let me just quickly give you my background, though ICSI has already introduced. But I've been actively working in the IBC space since 2016 and in my various avatars. And I have been taking up mandate after getting registration in 17 as IRP RP since 2018. So far, I have completed 5 assignments as with the resolution, and currently I'm handling 2 of the mandates which are currently under CRP. 2 of the mandates, in addition to that, I have handled as IRP. So I've been handling mandates which are basically diversified into various industries. So starting from EPC, defense, partly, steel, then cement, then hydropower, real estate with home buyers, and the latest one which I'm currently handling is real estate, and the another one is entertainment. So which is a core retail asset which I'm handling. So basis my experience with in handling these various assignments and the topic which has been given. So rather than basically focusing on topic which is very wide, and as most of us have been who are part of this current audience have been handling matters, so I would not harp on the specific provisions of IBC, CRP, and regulation. but I'll try to give color of practical aspects or more specifically of the going concern and related issues which a normal RP may face, and how in my personal experiences and the practical cases which I have handled, how we have tried to mitigate those risks, learn from them, and how converted them into best practices. So to begin with, I have divided the entire session into mainly three major segments. One is basically a role of resolution, IRP or RP, in case of managing the CD as a going concern during resolution. The second segment, I would first take up the some of the judgments. Now, see, there are many landmark judgments from Supreme Court and NCLAT and NCLT, so on and so forth, with respect to the various issues in IBC. But I have selected few which basically have a major impact or which are critical from the going concern point of view. So these may not or may not be relevant to all processes, but whenever there is a going concern related issues, at least I have tried to touch upon those issues with those selected case laws. And third, basically a topic which basically I would like to discuss and share with you is on the implementation of the resolution plan. Now, this is basically a specific period after the role of RP ends, after the resolution plan has been approved by the NCLT. So there I'll be taking up, practical aspects of what basic, again, this is my experience with respect to the resolution plan, where I have been directly or indirectly engaged in implementation, and what are the nitty-gritty issues, and how as a professional, whenever you are getting engaged, we can plan for those events. So I'll be taking up those in my third part of this presentation. So, ma'am, from ICSI, can you guide me on the, the timing for this? Because these are the broad three structures. So, is there any break which we have to give it to the participants, considering the 3-hour session which I am going to take, or how it is typically, it typically works? Because I am taking it this 3-hour session first time, so I am not familiar with how it typically works. So, can you help me with this, schedule, so that I'll within time limit I try to complete it, and then we have enough time for our participants to discuss and also share with others on their experiences and relating to these limited aspects. So from ICSI team, can you guide me through on that? Am I audible?
Yes, sir, you are audible.
Yeah. So, ma'am, do we have to give any specific break period between in this session, or I have to continuously take them through the session and complete it?
Sir, you can take up the session according to your comfortable.
All right.
According to
Thanks.
your comfort, you can take the session.
Sure, ma'am. Sure. Thank you.
You can take the break also if you require.
All right. All right. Got your point.
10-15 minutes break can be taken.
Sure. Sure. Thank you. Thank you. So, okay. So with that, let me allow me to start the session and discussion on this. So before we move on, just this is again a very brief fact on the number of cases which has gone into IBC and their outcome. So these are all very numbers which are available in public domain. But it is interesting to see the journey of this code, where we all as a professionals, being one of the key stakeholder and the service provider, we have seen, we have learned, and we have grown by handling these cases. So resolution, though remaining a very limited percentage of the overall cases which have been admitted, but as well as cases which are closed. But considering the overall motive and the intention of the code, there's a reasonable success under IBC. So even if you have to take that, out of 6,800 cases, or other 4,700 which are closed, 2,600 are basically successfully rescued companies, maybe by way of a withdrawal, settlement, or basically a resolution. But so far the code and its successes are concerned, we have seen its ups and downs, various issues, various bottlenecks. But we have been also equally fortunate with the regulator and who has been constantly pushing for update in the law. And as a result, we are seeing constant improvement in law as well as related regulation. So also with respect to now recently, there are two proposed changes in the law. One is basically focusing on making the resolution process more effective. Though basically, we have to still look into it because this is something which IBP has been proposed. So after various IP conclaves which they had, IP's discussion which they had, and also their discussion with the various stakeholders, including banking and financial institution. So those changes which has been proposed, also in terms of real estate, also there are fundamental issues or bottlenecks which were there. So they have tried to address it through these draft amendments which are though under discussion. But so just to cut it short, we have a regulator which has been constantly working, and yes, the regulator being regulator, we have seen a lot of movements or a lot of disciplinary action as well in case of this particular profession, where there are a lot of professionals who have been new or basically who have been dealing with these cases with best of their intention also at times are going through something which is again a very testing or difficult to continue or to handle these matters with this disciplinary in mind. But having said that, this is a professional, is an ever evolving, and we all are basically learning from this cases which we are handling and the kind of situation which we are exposed to and facing. So we all have our own learnings, and with that, I'm just moving on to the next slide. So on the first part, basically what I have done is just to categorize the entire presentation into four further segments. Is basically one is basically what is corporate debtor when, or the stage of corporate debtor when a CIRP starts, or rather commencement of insolvency. Typically, basis my experience, we have categorized them, and basis those categorization, I have further gone into in the second part with the issues or specific aspects which are critical in handling these matters, and then at later stage a very generic presentation where how as a professional one can plan for these three different type of corporate debtor basis, again with respect to the specific industry and otherwise. And the last is basically again preparation for this assignment, because each and every assignment, irrespective of the industry or irrespective of the level of operations, each assignment basis my experience is unique, and it definitely requires a different approach to handle specific issue irrespective of the industry. So if I'm handling multiple, be it real estate cases, or if I'm handling a manufacturing unit, or if I'm handling a core retail entertainment industry, each case demands a different approach and planning and other related aspects. And for that very reason, we have to have that preparation. So just I'll be highlighting on that. Nothing. Because the time is limited, though the 3 hour is a long period, but the kind of topics which I have to cover, the timing limited. But I'll try my best to touch upon all those issues with my personal experiences. So let me just take you through the presentation, which is typically basis my experience. What I've seen is that there are basically typically you will find three type of corporate debtors. So one which are having bustling with the activities, operational, huge ongoing cash flows, the company is running, plants are running, or the assets are operational. Again, corporate debtor is having fully staffed and continuously paid, regularly paid employees. Again, the last aspect over and above this operational part is basically in this type of corporate debtors, the promoters are also actively engaged in the operations of the corporate debtor, which is basically a pre-ICD period. They have been actively engaged. The type 2 where we have categorized is the operations or other type of corporate debtor which have limited operations, limited cash flow, or operations are on the verge of closure because of stress and other related things, mostly understaffed as compared to the operations or the size of the company, inconsistent workmen and employee payments, under-maintained or limited maintenance at these plants, and very slow-moving projects or litigations and other related aspects are huge. Again, statutory dues, so again, non-compliant, not for a long period, but at least non-compliant for a limited period due to basically stress into operations with respect to statutory dues and other related compliances. And the type 3 category are the companies where the company's operations are almost zero or hardly anything. There are no effective cash flows which are being generated by the corporate debtor, deteriorating plant conditions, and again, there also I think we find generally some litigative issues or some commercial disputes or some related aspects. And here also, basically, in these type of companies, what we have observed now that varies from case to case, but promoters are not actively involved in the day-to-day operations of the company because plants are shut, there is not much activity going on. Other aspects are not something which I want to touch base upon right now, but these are the broad three categories which we have been seeing in this. So now in the second, going forward, I'll be taking up related issues which are connected with the operations as well as with the CRP process related aspects, and how within my limited experience, how the difficult situation or critical aspects which we have come across, I have come across in handling some of the matters, and I'll be taking up or rather highlighting them. So first, basically, biggest and the first and foremost action point is basically a control and custody of the assets. So naturally, because many of us have handled multiple assignments, so this remains basically a very core aspects of the process. Having said that, in a type 1 company where the this is something which will be applicable to all three type of companies irrespective of the size of operations, hardly any operations or operations, because this is the core of our job as a insolvency professionals. So, but again, there are challenges which we face, and so do I have also faced certain challenges irrespective of the case which we have handled in 2018 or recently. There are certain challenges which are applicable to all processes. So first and foremost is handing over and taking over the assets and the records of the company, seeking information from the employees, personnel of the corporate debtor, insurance of the property to protect and preserve the value of the property, evaluating of the security or protection measures to protect the assets of the corporate debtor on ground or at the location, and smooth transition from the promoter management to IRP. Now, this particular aspect, except type 1 or type 2 partially, this is not something which is more or less applicable in type 3 because there the operations are hardly anything. But for operating companies, this is a very vital action or other challenge which all the IRPs generally face in the transition phase after the order has been received and effective control being implemented by the IRP. So here, just to give you some of the examples now, there are mitigations which definitely as a RP or IRP, you have to prepare a list of records. So over the period, what I have learned is that there are best practices which have evolved mainly on the custody of control. So first and foremost, which I have seen is in multiple cases is now even the practices of immediately when you enter, basically the list of assets, locations, location wise, and even if required, the panchnamas are being basically executed and recorded so that there is a proper evidence of the assets of the corporate debtor which we basically IRP has taken control over. So this remains a very important aspect. Second is what I have seen is practically as far as the going concern is concerned, the insurance of the assets again, because it's a very vital thing for any corporate debtor. Operational companies, yes, it is must, but it is easy to get. But mainly in terms of type 2 and type 3 companies, more specifically type 3 companies, personally, we have faced certain serious challenges in terms of getting the insurance done of the assets of the corporate debtor. Now that also varies from asset to assets and the type of industry. So just to give an example, I was handling one of the hydropower assets, which is a partly completed power plant. And there we had the issue of getting this insurance renewed during the CRP. Now, what happens is that for partly completed construction assets, there are different type of policies which you have to avail, which is basically, contractor insurance risk policy on. So there are different insurance products. So as a RP, I had to first get into the understanding of this. Now, the second issue was that the project was non-operational for more than 3 years. Now, as a result, though the project risks were high because the project was located in some remote area of Uttarakhand into that mountain ranges, and the related risk of rains and other damages were huge. So, the insurance company, when we entered, categorically denied that we are not willing to take, continue the cover on this. And if you want to continue, the issue is that either you pay a premium which is way high, and still you have to show some maintenance and other activities, or basically we will not be able to continue. The second term which they also put in is that the limited term of the insurance, because they said that we don't know the risk, but you are not mitigating risk, you are not restarting the operation, so the risk continues. So we will not be able to give you the insurance cover for the entire year. We will be only covering these assets either on a half yearly basis or a quarterly basis. So just to conclude, the insurance aspect becomes so critical for all the assignments which are basically under CIRP. So as a RP, what I have learned is that one needs to have a comfort of one or two insurance brokers who can get you an understanding this, or basically some sort of understanding of the nature of business and the insurance cover which is required. So in my experience, I was fortunate to have connect with the insurance brokers, various insurance brokers who have been dealing with various kind of insurance cover for the various kind of industries and the assets. So that helps us into getting multiple quotes, understanding of the issues, and how basically you can protect the assets. So this one such experience which we had. Second is basically custody and control again for the same project. It was during peak COVID and I had to go and take custody and control. Now the issue for the type 3 asset is vis-a-vis the type 1 asset is that, because of non-payment of various dues to the local vendors as well as to the employees, it is very difficult to get this custody and control initially. But again there, the COC came to our rescue, and for insurance and other aspects, it took time. It was not easy, but it took time. But then finally we could get this support from COC through which we could get these assets insured and took the custody and control by basically regularizing some of the payments which are basically due during the CRP period. So this is just an example of how basically, any case which we take up and may face an issue. But I believe that these are the initial and the must challenges for going concern or otherwise type of, ongoing operational company or otherwise, which basically, we have to take care of when we take custody and control of the assets. So during the course of this presentation, if any participants wants to interact or they have something, they can very well raise their hand on. You can, we can either between after the first session, we can take their queries, or in between, if they have any concern or any clarification required, we can take that up also. Moving on to the next is again, as I mentioned that my focus will still remain throughout the presentation on the going concern, operational heavy and non-operational heavy aspects of the CIRP. So the second issue is basically in relation to the cash flow. Now, basically, because of the best practices which have been evolved, the challenges remains, or rather the action which our IRP and RP has to take vis-a-vis the challenges which we face is first and foremost is the custody and control of bank accounts, both active and non-active. Now, this becomes for a operational type 1 companies is must, but it has a consequences also. So I'll take you through the practical example which we face and then how we mitigated that. Understanding of the extent of current projects and operations. Again, this becomes very vital for type 1, type 2 company. Type 3, typically because, there are no operations, it is easy to understand and at least take custody. So first part, it is easy. for all of three. Second part, mainly on a cash flow and control over cash flow, becomes very difficult for type 1 and type 2 because there is a constant risk of basically operations or hindering of the operations. So one hand you have to completely manage the operation or cash flow, and on the other hand you cannot allow those getting impacted because you are getting into the in the management and taking control of those day-to-day operations. So understanding of the reasons of failure for continue to or to start the operation, because this is a challenge where type 2 company where the operations have drastically reduced, or basically because of some issues or disputes or operation issues, they are not able to continue the production or the operations of the company. Again, the analysis of the cash flow from plant projects and forecast the expenditure including CRP costs to run CD. Now this also becomes very pertinent aspects, which is once you enter into it, one hand you have the process related activities going on, and other hand the cash flow. So this is again applicable and the more challenging part for type 1 companies. And I'll take some practical example which we face and how we try to overcome. The another part is basically analyzing the commercial contracts. Now for a operating, non-operating, hardly operating and hardly any zero operation company, the contracts are very vital. But more so in the type 1 company, what happens that because it's a going concern, unless you understand the core supply agreements or service provider or the agreement with the customer, it is very difficult to get complete control over the cash flow. Now, just to give you an example, now, of the third is, sorry, so before I start, so last is basically ensuring and understanding the roles and roles of employees, management and workmen, and deciding on retrenchment and termination. So this issue basically more or less is applicable on type 2 and type 3 where the operations are not there. Type 1 is basically you still have time if the cash flows are permitting, you still have time to optimizing the cash flow, which is basically not an immediate requirement once you enter. But over a period, yes, this also becomes a vital point for type 1 companies. So because in type 3 where the zero operations or type 2 partial operations, what happens is that in many of the cases where the companies are operating at a group level, at times they are overburdened with the group level team at the corporate level, or vice versa where there are hardly any employees. All the employees are at the group level and there are no employees at the corporate level. So both way it is difficult for you to take custody in type 2 and type 3 companies. So understanding of that and then deciding the roles and responsibility within the best available team of RP internally as well as with the team of corporate debtor becomes very critical. But mainly I will highlight on the operational part of it. So in some of the cases till today, mainly when we try to change the signing authority in terms of bank accounts. So getting bank accounts is slightly difficult, but nowadays we are seeing that cooperation and with the help of financial creditors, getting bank account detail is not difficult, but changing at times what happens for the continuously operating company. Sorry. Yeah. Anybody saying something? Oh, sorry. Yeah. So what has happened in some of the private banks when the accounts are getting operated, one of the leading private bank had created the issue of that they will not change the signing authority unless they first they will be debit freezing the accounts, and the same will continue for another 7 to 8 working days, and after that there will be changing signing authority. Now that creates a huge problem for an operational company where the daily cash flows are in quantum, and you cannot allow also that bank account to be operational without changing in signing authority, because in these type of cases what happens when the operational companies are there are PDCs. Because of this stress, there are PDCs or are issued, so they may get encashed during the CRP period, so that risk remains. Another risk is basically the operation part, because there is a continuous operations. If there is a business like a core retail where you are on a daily basis, companies are making hundreds of payments, or even in manufacturing where the plant is operational, you have a daily cash flow, cash outflow. Until the time you understand the process and till the time bank actually change the signing authority, it is very difficult for a RP to take proper control. Otherwise what happens is and not naturally the control takes time. So then it will lead to a situation where some of the pre-CRP payments, or basically some of the payments of which are not due or which are not accrued during the CRP period will be paid by the existing team of employees or under the influence of promoter, and that becomes difficult situation, because then again you have to go and challenge or you adjust it. And to understand and explain them this situation and understanding, it is very difficult for an ongoing company, because somewhere they all know as a supplier that there is an issue, and on the contrary they will not cooperate, because the moment their payments are not made, it is very difficult for an RP to continue and run the operations. So in that situation, what we did in two of my assignment is that we basically then at least dig out the information of who are the signing authority banks, and we made sure through our communication meetings with them that you are now sole responsible, and the sole responsibility of you, whoever is the concerned officer of their accounts or finance department, whoever was responsible for making payment, that unless you consult and you take our approval, and if you make payment, then you will be personally held responsible. So all those additional, checks, balances, as well as additional policy measures which you have to put in and explain them, so that at least you are covering as a RP. I covered my risk and made sure that there are no payments which are made which are not authorized till the time there is a change in signing. So this one such thing which creates an issue. Second is in terms of contract. So why the contracts are important? Now, in one case where I was handling it, there was a basically, it was a power generating unit. So then what happened is that it was a solar power unit. Now, typically in the solar power, what happens is that you have fixed assets and fixed O&M, operational maintenance contract, with the supplier of this wind turbine only. It was a wind turbine. So not solar, sorry, it was wind turbine. So wind turbine, you have fixed O&M operators. Now the company was constantly generating power. There was a fixed O&M guy, and there was a constant sale of power under the PPA with the state government. Now, when we entered into, basically the corporate debtor didn't, or the people of corporate debtor, because this is a very smooth sailing business where as a RP to take control and to take action is very simple, because these are all autopilot kind of a businesses. But at the beginning, to understand that who all are basically O&M guys, what are their dues, what are their positions, to explain them, and as well as continuation of this PPA, because industry-wise, there are additionally compliances and mitigation, actions which you have to take for continuous power supply and for the reconciliation, as well as for the customer, who is basically a state government, for them to acknowledge that this much power has been supplied. So unless you get into these commercial contracts, which are in relation to the operations, it will be very difficult for you to then, later on reconcile and create those issues and then handle it at a later date with those stakeholders, vis-a-vis analyzing the same at the ab initio. So typically in these type of situations where the operations are ongoing and you have been basically appointed as IRP or RP, as the case may be, so it is advisable with the consultation of the COC to appoint some technical experts who can actually guide you through with the industry, unless you have handled those matters. Because see, for as a RP, it is, once you handle those matters for one or two cases, or basically in that specific industry, it will be then easy. But otherwise, it becomes very difficult to take control when the company is bustling with the activity. Now, additionally, what happens, another case is what happened is that in one of my cases, there were lease agreements. So the company was into operating certain centers, and those centers are not company owned, but there were leases. Now, typically what happens when you have a leases with the various, almost 14, 15 leases were executed by the company. Now, some of the leases were expired. Some of the leases are on the verge of expiry when we entered. So they were getting expired during the CRP period. Now, for both the reasons and considering the legal precedents as well as dealing with this, so once CRP starts, basically you have a backup of moratorium. So there has to be an extensive use of that moratorium, has to be done by the RP, more so in the operating companies, because that actually saves the company from any loss of revenue or any loss of operations, which may basically affect the ultimate resolution and the larger goal. So in this case, what had happened, we basically created a pool of contact and we have to personally go as a RP, personally go negotiate and make them understand the moratorium, which they themselves knew. Many of them were the large lessors, so they knew, but they never wanted to acknowledge the applicability and the consequences of those lease premises which are under control of corporate debtor, and through that the under the control of RP. So we had to basically go them, sit them, and surprisingly, after a lot of deliberation and the commitment, which are basically covered under the original lease agreement. So we kept on honoring the payment wherever the lease were expired. We could successfully get those leases renewed during the CRP period, which was a mammoth task. But because we are into that dominant position, the company was doing good, company was operational. We could get this lease renewed. Still, there are certain leases which are getting expired, and the ongoing issues are there. Reconciliation, convincing them for the extension to this remains an issue, because that company which was operating, they had only lease assets and they were operating those centers and creating business. Now, for the incoming investor, this becomes a very vital issue, because if the leases are not valid and they are expired, for an incoming guy, because it's not owned, the only thing which you have is those depreciable assets which are located on those locations, and to convince them on the that the unit is viable, all those centers are operational, and the leases will be renewed, becomes all the more challenging for the RP and the COC for at the time of resolution or at the time of submission of resolution plan. So, or during the negotiation. So these are the few things which we have come across, and there can be many which we can take it up. But just to give you a highlight of how the critical cash flow and the controlling of the things. Similarly, when it comes to preparation, so now if you see the latest amendment which the IBB has proposed, there also there are two critical aspects of the CRP. Now, one is basically a frequent meeting of COC has been proposed to be mandated, and second is basically with respect to the CRP cost. Now, as per the proposal, the entire CRP cost, be it specific process-related activities like appointment of professionals, RP, IRP, IP, and valuers and other related costs, and cost for running the operation also should be considered as a CRP cost, and the same has to be approved by the COC at a regular interval. Now, as a matter of best practice, many of the RPs were doing it because whenever there is an operation, it is not only the RP, it is the COC who should be involved, and there are definitely specific instruction in the decision making, not restricted to section 28, but all other related aspects of operation also, the COC has to be equally engaged, so that then there are better outcomes which can be achieved, and continuous operation and related steps. Like some of the projects now, when there is a going concern entity, the another thing which we have faced in one of my cases is that capex, which is requirement of a recurring capex. So what happens in that particular case? What will happen is a company where every year, because it's into entertainment, every year you have to incur certain amount of capex, and if you don't incur that capex, you are basically losing on footfall and your customer, and which will affect your revenue. Now, in that case, we from the day one, once we understood it, we got the data, we tried to work out with the corporate data with those limited challenges of with the challenges of limited data sharings and other aspects. We basically parallelly prepared a plan for capex with the help of company and the expert, and on a regular basis, the capital expenditures are being approved by the COC. Now, there basically what we could achieve these approvals and clearances from the COC, because on the contrary, the COC is allowing us to run the operations and making sure that the corporate debtor is alive. And on the other side, COC is basically giving an open hand to RP, that as long as the amount which is been generated, or rather from the positive cash flow of the company, you can reinvest in the operation. So with that comfort from the COC, we are able to run the operations, or even for that matter, wherever required, we are also planning to expand the operations also wherever possible within this limited within the cash flow which has been available to the corporate debtor. So preparation of budget, approval. So these are all additional steps which you have to take more specifically for the type 1 company, which may not be there for type 2, type 3. But for the operational company, these are very must, and which basically ultimately help the RP in achieving the objective and under the CIRP, which is maximization and resolution. So though these are very small and basic and assumed points, but this has basically helped us in taking up various aspects and handling the matters and generating interest. Next is claim. So now claim again, see, inherent claim related issues will always remain. So I don't want to touch upon these claims where there are OC related issues in all the claims, FC related issues, home buyers related issues which you face, and employee related. So some of the matters which I have handled, I'll just rather than taking through on the entire thing. So these are all basic challenges which all RPs will be facing in type 1, type 2, type 3. But let me just take you through the operational company with operational, and the issue which we face and how we try to mitigate that. Now, more specifically, when there are ongoing operations and there are regular bill settlements, regular payments which are being made, the biggest challenge for the IRP and RP is to convince the vendors, convince the statutory authority and all other stakeholders whose dues are outstanding as on ICD to file a claim and settlement of all the costs which are being incurred after the CRP date. So that remained a major challenge for us, because typically when there is a company which is an ongoing account, regularly the services or the products or the supply has been availed by the corporate debtor, and the corporate debtor has been regular, or rather there may be 2 or 3 months delay, which basically creates a situation of filing a claim. Now there what happens that now mainly specifically vendors who are MSME or a small size vendor, there the issue is to convince them and to make sure that there is no violation of law with respect to the payment of pre-CRP dues. So that remained a major challenge in some of the cases where the operations were on, and which may basically cause an issue, because where the business is like one business which I mentioned about the centers. Now there the issue was that they were basically creating issues and ruckus in front of those centers where the customers were entering or near the entries of those centers. Now that creates a huge problem for business and other operations. So there basically we have to think out of the box, and we had to think out of the box, and we could work out some solution where for a working capital support, we created with the approval of COC, we created a pool of fund where we supported all those MSME vendors. So naturally the company suffered losses and the discontinuation operation during the COVID, and naturally the supplies were also suffered because of that. And after the COVID, the company revived, but unfortunately for the company that the CRP was initiated. Now in that case, where the both stakeholders have affected, we created a pool of fund for them for wherever the need-based working capital as an advance will be provided. Having said that, they have to comply with the law, they file a claim, and this advance which has been given, if the company continues for operations and we still deal with them on that, this advance becomes either refundable if there are no dealings, or basically we will be adjusted against the future bill. So midway has been worked out, but for them to file a claim and convince them where the operations are on, for them to understand that the company is not doing good in spite of the ongoing operation is very difficult to convince, because for them it is the company is on, the company is making money, but then why their money is not being paid. It is a very plain vanilla kind of a situation for them. But for us, it is quite different situation where the claim has to be filed. On the contrary, we have to also make sure that the operations are on. So this is one such issue which we have come. Another issue in case of home buyers. Now, one of the cases where I was handling as matter as a RP, where there are more than 300 home buyers were there, and they had booked, and there's nothing effectively happened on the ground. The plot was, it was a plain real estate development project where on the ground there is nothing which has been done. It's a privately acquired land, and after booking, so almost after 7-8 years of booking, nothing had happened on the ground. Now because of that, to gather these home buyers, first of all, we never had the information that how many home buyers were there, but with the help and right support from the COC and the authorized representative, what we created is a mechanism of public awareness. We went out, including the project sites, even to the local communities near about the project, to aware and spread the news that this company is into CRP, and whoever has basically booked their units under this project are requested to file a claim. Now AR also here helped us in conducting those sessions, educating them how the claim, the claim documents and other related things has to fall in place. In that case also, what happens is typically for home buyers, there are different interest rates which are applicable. Mainly under the CRP regulation, there is some 8% odd interest rate is applicable. Under RERA, there are basically home buyers who have challenged the, who have gone into RERA against the developer. So there also they have got some order with the interest. And with the no, because almost after, their advances were paid almost 8 to 10 9 years back. So because of less of records, how you basically apply the interest, how you basically create this is principal, this is interest, and then you create all this. So that becomes a major challenge as far as the real estate and other related aspects is concerned. So that is basically nothing to do with type 1, type 2, type 3. But now let's put in a situation which I personally may not I have not handled, but if the project is on, the project is a going concern, there is a construction activity going on, and the COC is willing to fund it as envisaged under in the even the latest amendment by the IBBI. Now, in those situations, what happens? How you basically ask them to file a claim, reconcile the accounts, and parallelly you have to also make sure you are demanding the installments, utilizing those installments for the specific project. So basically, planning and taking right steps with the proper strategical support from the AR becomes very vital in handling these claims. There are various other claims, like in one of the case, the employees were not willing to file a claim because they said that the company is on. We are not interested in filing our claim. Why should I file claim? Because if you file claim, we become an operational creditor, or basically our claim will not be settled. This is their experience. Because what happened in this particular case, the entire group, so there was one group. So group main entity, the holding company had gone into CRP, and then there are various project entities. So I was handling one of the project entities, which is a wholly owned subsidiary of the holding company, which was into CRP. Now the employees had their own different learnings from the CRPs of the holding and the other fellow subsidiaries. So they were not willing to file their claim in this process. They were under impression that if basically the company will revive, it is a duty of RA to make all these payments, and we are not willing to file a claim. Now, as a RP, my intent was, because see, there were very sleek team of this project and there are hardly any employees, but they were very vital for the revival as well as for the RA when they take over for the revival of the unit. So considering all these aspects, we have to devise a strategy where we convince employees and the workmen to file their claim. But at times it becomes very difficult in the operational company to convince them that why their salaries have not been paid and they should be basically filing the claim. So these are the claim related issues and what we have faced practically. Yeah, so I'll move on to the next. So again, bid process. So bid process, again, it's the steps wise. I will not go into the detail of which are the steps, how basically though even the specific issue other than the data, because data remains a challenge in all the cases. So that remains an implied challenge in all the cases. But what will happen is that what happens in the type 1 company where the businesses are on, the operations are on, we have come across in 2 of my cases, what we have come across is that when we basically open the data room, the status of the corporate debtor has slightly changed. In one of my cases, surprisingly, it has physically moved positively. So the turnover which was there pre-CRP, a year ending pre-CRP, was basically lesser than the turnover or the numbers what we have achieved in the CRP. Now, that's where the expectation of the PRA increases, because then when the operations are on, they're able to see everything. And then the PRA again getting into the situation as if it's a normal M&A or a normal acquisition without recognizing the fact that the company is into CRP because the operations are on. Now that leads to an additional challenge to the RP, because what happens that they want everything advanced. They want to make sure that the information data relating to operations are up to date and uploaded in the data room for them to conclude. Now what happens for us, the main challenge is the closure of earlier financial statement if it is not there. how to carry forward them, many of the liabilities in the absence of claims, in the absence of data and finalization of accounts. Because one hand, what they are seeing is the activity, and that's where the value has been seen by them because the operations are on. But to support that value, whether whether it is actually the value is there, because see what you see when we when we supported them during the physical visit and the due diligence, they could easily realize that the activities, it's an operational company with a proper existing management in place, with a proper hierarchy, and critical positions are there without any gaps. But for them to rely and convince and put a number, they definitely need a supporting data. And that's where, because of lack of data of the previous year, it is difficult for RP to close the financial statement of the current year. Now, there may be issue in relation to statutory compliances or payment of dues, because of which you are not able to file those returns. Now, GST is, we are fortunate that GST has considered that. But, for example, there are ongoing assessments. Though we convince them on the past liabilities, how the code conducts or how the code views the past liabilities and the dues, irrespective of the ongoing litigations or ongoing disputes. But for them, and to convince them becomes a different challenge for the ongoing concern, because their expectation increases when the operations are on. Another is basically, again, many of the cases, they are also expecting the RP to prepare a projection and give them. Now, this also becomes a very tricky situation for RP, because the company is into CRP, though RP is handling it. It is basically, for the RP, it is a temporary role. And when, it is difficult to underwrite for RP to underwrite any projection or the future specific projection or numbers. But without that, for them, it is difficult to, put final number, because anything which is applicable to industry and all. So these are the practical issues which we have faced with the PRAs in terms of, operational companies which were there. In one of the cases, which was not type 1, type 2, but type 3. Now, what had happened is that when we, as a RPN team, it was basically, as I mentioned, this is one of the hydro power asset, partly completed and located into Uttarakhand. So there, what happened is that the COC, because there was no value, the value which was offered by the PRA in the first round of bidding was not up to the mark, and it was COVID period. So there were hardly interest in the investments and other related strategic guys to invest in the assets. So offer was very low. Fortunately, 21 was a period when everybody, the entire world was talking about renewable, and then there was a huge interest in investing in renewable. So we started getting, after I filed as a RP application for liquidation, we got an interest from multiple local as well as international strategic buyers that they want to bid under CRP. Now, from RP side, we have clear communication to them. We discussed that issue in COC also, that these are the interests which are coming up, but now we have filed the application, so we cannot do anything. So we had a discussion with them. We said that if you are interested, you can approach adjudicating authority, because that's where the decision making is pending. We, as a RP and COC, have completed our role and we have nothing to add. Now it was peak in the month of December. The NCLT decided, considering the increase in interest in the type of assets, they said that you have only got 2 months to complete the entire process. Now, in that process, the biggest challenge for us to reach that place in the December and to complete the due diligence within, experts coming from outside India also within limited time period. But with the help of team of corporate debtor, and that we could do it. And let me tell you, something which you do as a RP, slightly an additional steps or and going extra mile, it actually helps in achieving the larger purpose. So in the peak of December, we were at the sites and we were fortunate to get cooperation from all the corners, though the situation was not very good or encouraging. But at the result, the entire process got concluded, including the approval of COC within 2 months. COC could achieve the resolution plan worth of almost 4 times of the value which was received in the previous bid. And that project has now been revived and the construction has again started and the RA has completely turned around the company. So, these type of cases where we have to go one extra mile and to put some extra efforts becomes very critical. So these are basically, a going concern related, I would not say core going concern related issue, but wherever, even if there are not a going concern issue, but going one extra mile actually fetch a really good result in the interest of process. Yeah, this becomes again a major issue. So this is an issue for all the type 1, type 2 and type 3 companies, let me put it this way, because the compliances are always a challenge for type 2 and type 3 company, and that is okay to begin with. But for an operational company, a non-compliance, be it GST, be it TDS payment, be it MCA non-compliances and other non-compliances, it becomes very challenging to run the operations with those continuous non-compliances. Now, see, GST, we have some comfort, but what happens in the GST now? If the activity or the, if it is a manufacturing plant or a retail unit which is bustling with the activity on a daily basis, there is a number of transactions which are happening. To stop and get a new registration becomes a challenge, because the moment you change the GST registration, now if an entity has got say 13, 14 GST registrations because the operations are spread across. Now imagine a situation where we try to change the GST registration with all the proper documents, whatever it is. GST department itself, it takes 10 to 15 days. I mean, that depends on the clarification which they seek, because as a RP, still the department doesn't have, they do change, but then they have their own set issues, checks and balances, which are basically time consuming. On the other side, the moment the GST numbers are changed, I have to basically keep it ready, and we don't know. So entire billings of ongoing sales or revenues have to be changed. It has to be implemented across locations. So all those become a real challenging task in case of a non-compliance, because there are dues which are not paid. So ideally there has to be claim, and there has to be new registration, because without that there will be no regular compliance for the operations. But these type of hindrances are always there, mainly for type 1 company where the operations are bustling, other companies bustling with activities. Otherwise type 2, type 3 is manageable, because you have time to get the new registration. You can then accordingly comply with. Also, another operational issue which we face in the operational company is that because of the non-compliance by the company, mainly on GST and TDS, at times the service provider, in one of the cases I mentioned about the lease arrangements, the lessors are not ready to cooperate because there was a TDS dues which has not been remitted, or they have not got the TDS credit, and for the CRP period also, because it becomes difficult for them, for an RP to convince them on all the operational and non-compliances, because for them, what they are seeing is that the company's operation. We are least bothered about what issues you have, whether it is CRP or no CRP or whatever your processes are. We see the company is making money, we want our money. So, that creates a more complication for RP to handle that situation. Having said that, because it is very clearly part of our job in RP, so we have to take initiative, we have to manage the stakeholders, but this remains a challenge for the operational company as compared to the non-operating companies. Along with there are, in some of the cases where the companies are operational, there are basically FEMA and RBI related compliances, which also becomes a burdensome for the RP, because if there are past dues or past non-compliances which has been done and you don't have documents, and the company requires to regularly import or export, that creates these type of non-compliance creates the hindrances. So there also we have to, so in one of the cases we had the issue of import where the company was regularly importing material and we had this non-compliance of bill of entry of the past period. So we adopted, we planned, we met bankers, because bankers are also not willing to continue the services of authorized dealer for remitting those foreign exchange. So we had to have that interim arrangement with some other guy. Then after some time we convinced the bankers, we followed the process. But somehow still in the banks also, irrespective of the IBC, there is a recognition of IBC, because for them the compliance is supreme as compared to the what the company is going through. So this also creates an additional burden for RP to more so in the operational company to handle and then take things forward. Yeah. So another is basically a litigation. Now litigation is also something which is a very peculiar and a difficult task, more so in the operational company than the type 2, type 3 company. So Type 2 and Type 3 may also have some of the issues which are vital for the process, but more so on the going concern basis, because see, for Type 2 and Type 3, there may be cases with the customers or where there are huge, because of the litigations or arbitration, there are receivables or there are benefits which the company can avail or corporate debtor can avail. But having said that, in general, for an ongoing company, the handling the, because see, because of the past non-compliances or rather pending assessments or the audit by the GST and other departments, this basically creates an additional burden along with the operations, because same way you don't have data, still you have to handle, still you have to give the data, and you have to support all these activities in spite of the basic fact that once the company is resolved or going into liquidation, it's just a claim or the crystallization of liability and the claim which will follow by the various stakeholders who have be it statutory authority or the commercial, suppliers or the vendors or other parties who have claim against the company on account of this litigation. Again, litigation during the NCLT also becomes a very tiresome or rather difficult. So I would not take much time, but let me give you one example, a very classic example which we had faced in this, that the company is operational. Now, what had happened is that the brand was a major asset of the company being in the retail asset. And the brand was transferred just before the initiation of CRP. So after the pronouncement of order and before the initiation of CRP, the brand was assigned to some third party. Now, the brand per se is an IPR issue. It has nothing to do with the NCLT or NCLAT. But once you are into NCLT, as a RP, it is my duty to make sure. Hello? Yes, sir. Hello? Yeah. So if you can put yourself on mute if you are not seeking any clarification. So in that brand, what happened is that now immediately after initiation of CRP, within 1.5 months, basis whatever documents we could gather, we filed an application under Section 66 along with other PUFE provisions that this transaction has to be notified. Now, but the consequences on the operations, let's understand that, because without brand, you cannot do anything. Effectively, if we see that the assignment agreement is in place and you still have to do a business, and without brand, your business automatically will go down or will get a major hit. We were fortunate to get an interim stay, but limited to the trademark registry. That trademark registry cannot transfer through NCLT only. So the NCLT granted an interim stay that you cannot transfer it till the time NCLT clear the matter. Now, it's been almost more than a year now to conclude the matter, and the business is on. Now, what had happened or what is happening is that there are two companies who are utilizing the brand. Now, if you see that the brand is getting over exploited, because brand has a certain value of creating business. Now, that value or the business generating capability has been utilized not only by corporate debtor but by the other company also. So as a RP, again, we had to file an additional applications supporting this, that there are consistent losses to the corporate debtor because of the brand which has been misused by the or rather used by the other company which is beneficiary under that. Now NCLT is basically not concluding this, because for them what they are mentioning is that the brand is under dispute. Till the time we decide on that, we will not do that. Now this issue is not restricted to that. Now let's understand the brand is so critical to get your domain. Brand is also equally critical. The brand name is also equally critical to get you through domain all the email IDs. So there is your brand is also equal because brand is connected to your domain. Now domain is also connected to all your social media handles. Now imagine the business impact of one PUFE transaction which has been executed on the ongoing operational business. So again, for that matter, again we had approached NCLT on giving the relief that the domain should not be transferred, or we should be equally allowed to get the usage of domain and get it. Now NCLT in its own seat courts will be taking and deciding on the matter, but the damage to the corporate debtor and its operation is huge. So, and in spite of all this, you are handling. Now practically what happens that because the domain you have to utilize to update all your regular update also on the NCLT and IBC proceedings, what is happening into the process, including your claim, your Form G, your public announcement, everything has to be uploaded on that domain ID or website, I would say. But that access you limited have access because of the domain that has got transferred to that. You have to create an additional domain name. You have to get the additional how basically, so all those practical issues over and above this, because of the litigation, become so complicated to run a company which is normally otherwise operational and easy to operate. But because of the inherent issue of the IBC when it gets entangled and challenges of the litigation, it has become very difficult. But in nutshell, for the best practices, I would not say that, there are basically periodical update or review, update to the COC as well as to the adjudicating authority about this through your progress reports and others which we can do. But having said that, this at times creates some of the issues. Operational company, you face certain issues which are difficult. Recently, I think few months back, there's a company called Shakti Bogata. There was a judgment where that RP went to High Court and got an interim stay, but there the brand was not transferred. During the CARP, the other parties were utilizing that. So there the brand was not transferred, but it was with corporate debtor only. But it was exploited by some other companies, and RP could get a stay from the High Court and stoppage on the usage of that brand name. But each and every case has those own nitty-gritties and issues when it comes to operations combined with the process-related nitty-gritties. So that's something which is critical and has to be tackled tactfully. Yeah. Last is stakeholders management. Now this remains an very critical part. Be it your COC members, be it just a minute. Yeah, sorry. So be it your stakeholders, COC members, or your PRAs and other various things. So I would not, with the limited time available, I will not go beyond certain thing. But basically, stakeholder management is a very critical thing, which as a RP mainly on the going concern basis has to be done. Because as I mentioned, what happens is that you constantly need support if the operations have to be continued. Now the support from COC and again support from various stakeholders, including employees, including other authorities, because your focus is on basically making sure the operations are on, mainly on the type 1 company, so that the company doesn't lose value. Second is basically compliances and other things should be on. So handling the relationships with all the various stakeholders becomes very critical part, which is over and above your process related activity which you have to do. Now say it is as simple as employees. Now when you have enough cash flows, you should have enough liberty and you should basically honoring those payments so that comfort which you can bring in, so that your bid process and other related activities are properly supported by them, and you get or you achieve the results along with the COC which are required to be under this process. So again, keeping this entire process as fair and transparent becomes an issue, because nowadays there are practices where more so in the type 1 companies where the operations are on. Now let's understand the situation. That's why I specifically mentioned in my first sheet where we created 3 different bifurcation of type 1 company with the operation, is that type 1 are the companies where the company, if it's bustling with the operations, the promoters are too engrossed and engaged into day-to-day activities in most of the cases. When RP comes, they see it basically a major challenge, and that's where basically recognizing the fact that no longer they are in control becomes very difficult. So that leads to a situation that creates an additional hurdle for RPs to handle these operations, because there will be at every stage all these promoters who have not recognized and understood the provisions of IBC will create issues. So not only managing operations, but related issues in addition to the operations will come if the companies are operational, because then it is easy. One who was in charge, it is easy for him to find a loophole. So all those challenges also become very apparent. Excuse me, if you can put yourself on mute.
अभी तो बात नहीं की हमने। मैं देख रहा हूँ ये ऐसे
Mr. Diwan, if you can put yourself on mute.
ये वाली बिल लिया ना तो ये
Sorry. So I was on the issues which are being created by the promoters in case of operational companies are different, because what happens when you start, as I mentioned about the other issues on the non-compliances, issues relating to the like say for example certain vital licenses which are lapsed, or the relationship with your stakeholders including the creditors or your customers. So they create an additional hurdle for RPs so that the process is derailed, and they are at times, some of the promoters are also willing, or rather put their maximum effort to make sure that the company is no longer going concern. So that remains or becomes an additional challenge, that not only handling operations, carrying out duties which are required under the process with the ultimate result of resolution or conclusion of CRP, vis-a-vis this additional challenge from the promoters, because they have certain vested interest to making sure that things are not moving as desired by the process, or basically the RP along with the COC are being blamed for putting the business down. So those are the additional challenges which I personally also are currently also facing, and in past also we have faced that there is a different interest again which is required to be handled. So in one of the case, surprisingly, what has happened is that one of the cases was a cement unit in remote part of Andhra Pradesh, where I was acting as RP. It was during peak COVID. They had more than 500 employees and workers residing in this premises. It was cement plant. So there was a colony provided to the employees and all. Plant was non-operational. Because the plant was non-operational, it was basically, difficult for the company to give them remuneration. But because it was COVID, peak COVID, to provide them basic health facilities and to make sure that, at least they get water and basic other facilities for relating to accommodation and electricity, we, along with erstwhile promoter and the COC, sat together and we worked out something where we could successfully convince the promoter on the certain receivables by the corporate debtor from their group companies to support them in their difficult times of the workers. And not only lenders, but this promoter also supported in the CRP cost by way of a settlement of the old receivables which were due to the corporate debtor. But this happens in a very rare case where you are able to convince and the situation also supports. But as I said, that some extra effort will also or always leads to something better than the accepting the existing situation. But just to cut it short, the stakeholder management becomes a very vital and a complicated issue, which as basically as a RP, you along with the COC has to sail through. Yeah, again, so for valuation and transaction audit, so as far as the valuation is concerned, so one particular issue for type 2, type 3 are okay, because you have whatever you have and you can basically basis that to carry out and support the valuation exercise. It's not much of a challenge, but mainly on type 1 companies, the additional the companies which are on going concern, the challenge additionally which comes is basically valuing the asset, because typically the valuation are as on particular date. So that is on ICD date, the valuation will be available. Now what happens? By utilizing these assets, the RP is continuing with the help of COC's approval, RP is continuing the business. Now there is a value which has been created after the business. So as far as the core cash flows are concerned, yes, it is easy to assume that this much additional cash has been generated. If it has been utilized for the capex, if the core cash remains, it's fine. That's okay. That can be considered and added to the overall value, and that's fine. But in case this cash has been utilized for the capex or for expansion, then how basically you create, because by the time you conclude the process or by the time you give the resolution plans are invited, there is a change in terms of value, definite change in the value of this asset which has been valued as on that particular date. and how critically we do it. See, all practical purposes, processes which are getting concluded in limited time period or over a time frame, it's fine, because that it may not make much of the difference. And the assessing the impact of the assets or the capex is easy. It's not that difficult. But where some of the processes which are operations are on, but processes are getting prolonged for more than 1 year, and there's a consistent use of existing assets which are valued as on ICD date, and there is an addition to the assets by way of a capex or expansion. So how we basically work on or to basically support the COC on that decision making of how the valuation have moved. So that becomes a very peculiar situation or a difficult situation for an RP as far as the valuation is concerned. So process-wise valuation is okay, because that's something which can be done and will be concluded. But the valuation per se after, or valuation of the as on particular date of getting the resolution plan or the last date of resolution plan becomes a tricky one, because that's where there is a change in underlying assumption of the assets and their life and other related aspects. So this is something which law doesn't provide it, but as a matter of best practices, what in some of the process we have seen and we have been observing is that cash flow or cash generation, a separate treatment under RFRP also getting mentioned, so that there's a proper treatment by the RA to be given for the cash which has been generated for the business during the tenure of CRP. And second is basically for the capex and other related part. I've seen very rare, but for that limited addition and a revised number, which is though not a valid benchmark under the law, but basically has some revised working in the original valuation and some valuation for the addition to the assets have been carried out for a very limited purpose in a very limited cases. But mainly in a type 1 company, this is also a challenge which comes where the operations are on and you have that thing. Second is another very typical issues which we have seen is that in case of a transaction audit. Now, see, transaction audit to conclude and to file application after getting data and all, they have their own inherent issues and which RP generally faces, and filing of application is one part of it. But what happens if the transactions are similar in nature till the time you took effective control, or after RP took control, any of the transactions which are in nature of PUFE but has happened during the CR? So there are hardly any cases which have been reported or the actions which have been taken. But for an operational company, these type of risks also increases, because see, for example, if the company is operational, you are exposed to normal frauds. It's not that the fraud which has been created. One is basically third-party frauds, and the fraud which has been created by the employee or the stakeholders of the company itself, where the RP is independent, RP's team or IP is independent, but still the fraud has been conducted or it has happened during the CRP period. What you do, how you basically tackle that situation. So under IPC, there are specific provisions which deals with this situation. But so just to give you a head up that during CRP also, if something happens, there is a recourse which is available under IPC. And RP is duty bound, because a going concern entity is like any other business, is exposed to all the third-party frauds and risks, which needs to be either mitigated or addressed properly if it occurs during the CRP. So that's an additional thing which can happen if the operations are on and the volume of operations, those things can happen if the company is exposed to that risk. So IT related, nothing much basically on just a minute. So IT is basically typical IT related issues. So when mainly on a going concern. So type 1 company, again, as I said, that type 1 companies are more exposed to this type of risk as compared to type 2, type 3. So the inherent data issue and all is, yes, that remains a challenge for overall all the type of companies which are under CRP or otherwise. But for operational companies, a proper control of everything, where basically your entire IT infrastructure and a regular checks and balances additional top-up policy, which not only safeguards the issue or the risk which the company is exposed to, additionally also cater to the risk which process-related risk which the company is exposed to. So, which is basically something which is required, thought through and put into practice when the RP is handling type 1 kind of a company where the operations, number of transactions and other things are huge. So that becomes a challenge. Second thing is what I've seen in another thing, because during CRP, not in relation to this, but for the transaction, I just missed on that part, is what happens when you are duty bound to conclude a transaction audit within the certain time period. You have concluded it, you have filed an application, and there is no bar in filing a fresh application also. But a regular search on your litigations, regular search on your ROC. At times, what happens when there is a group and other closely knitted entities are concerned, what happens is that there are transactions which are made effective by way of a backdated filing. And that at times, if it is affecting your operations, this will really hamper or affect it, because see, to create a document or backdated document or create a meeting and other related filing, change in MOA of a subsidiary, where you basically have a holding, you being if you are basically handling an RP of a holding company, but something which has been done to a subsidiary company, and which will basically impact the value of your shares which a corporate debtor is holding in subsidiary, which has been done by way of a backdated filing. So the RP again additionally has to, irrespective of the operational or non-operational company, but has to put an additional checks and balances with respect to a regular search, ROC search, not only for the corporate debtor, for the related party, so that any action which may have impact, at least either avoidance is not something which we can do if it's been done with certain intent, but definitely some immediate action can be taken and the damage can be minimized. So that is something which an RP has to look into. Yeah, section 28 we have partly covered, but just to for your reference, it's basically unavailability of internal cash flows and resulting non-addressal of critical issues, because this is applicable to all type 1, type 2, type 3, because each company will have something. Like as I mentioned about the insurance contract, now the company is not operational, but the insurance is must. You need cash for that. You cannot mitigate the risk of basically assets which are exposed to various risks without insurance. So insurance becomes a very critical aspect, and that cannot happen if there are no cash available to the company. Now, on the other side, now as I said, that when there is an operational company, now there are certain macroeconomical factor under which the particular company is operating. I mean, industry and factor affecting that industry. If that scenario changes, now for example, there was a COVID time where there are demand of certain thing, and after COVID, the demand or the market dynamics have slightly changed for the corporate debtor. Now, for that and to mitigate the risk, it is basically very critical for RP to project and take all related steps to make sure, mainly for the type 1 company, to mitigate those risks by way of additional measures, which includes the either be it on a marketing or be it on a operational, be it on a capex, or it can be mix of all. So to keep the company on, keep it competitive so that the value remains intact. So all those strategic decisions which one has to take with the approval of COC becomes very critical, which is basically, so section 28 is all, I would say, all strategic decisions which are critical for keeping the going concern and has to be taken if the going concern status has to be maintained. So which includes the interim funding for various purpose. In some of the cases, as I mentioned, that when a solely on subsidiary structure where you have a back-end arrangement, a back-end tie-up or a upward or a downward integration with your related party, maybe your early on subsidiary only, but still all those becomes very critical, more so when the process has started. So, for example, there is a company which is into continuous production and the entire raw material has been provided by the related party, or reverse, where you are basically producing a raw material for your related party, and because of the process, now for you to produce and sell it to related parties becomes a very critical part of for your value and your asset. So if from ab initio, if this has not been envisaged, and immediately after the initiation of CIRP, the process or the approvals are not taken, it may have impact on the process, not strictly from the value point of view, but from the compliance and the overall point of view, which increases risk of the RP. So so section 28, all transactions, not only this which are listed here, but all transaction in all are very critical and thought through at the ab initio of the process, because that becomes a very critical for RP to handle the process. Now again, amendment of constitutional document and operational purpose. Now amendment of constitutional document you may not require. In a layman terms, I mean, you don't have to do it. But now, say for example, you have to change the register office of the company. It is inevitable for you. Now, if the promoters are operating on the same premises and the going concern is there, you are impacted by the interference of that. And if worst case, you have to decide on that. Now that becomes a very critical part of handling the process. You have to change, you have to change. If that's a something which the situation demands. So it can be anything in relation to that. Now there can be an amendment, I mean, MOA, OA, there are basically stipulating clauses or certain things which are affecting the value of the company. And not only you, but also for your subsidiary. So there are actions which you have to take. Now see, unfortunately for current IBC, it is not because of absence of group insolvency, the control over subsidiary still remains with the existing directors, though you are the shareholder. But now, when you actually take the action, as I mentioned about some backdated transactions filed now or something, where the intent is to divert or dilute your stakes or to devalue or value erosion for your shares which you are holding in the subsidiary, everything to make it effective, you have to take all this decision, and more so for an operating company. So that's why section 28 is something which has to be thought through and at a regular interval, and the related approvals has to be taken, has to be approved by the COC, so that the processes are not getting impacted. Again, change in management, as I said, that there may be hostile situation where you get into this, the company is operational, but one fine day you find a situation. So in my personal capacity, last year we have found a situation where so there was a company where there was a holding company, and holding company, I was acting as RP, and there was a subsidiary, and both are having the similar business lines. Now, what happened that when we started this ERP with the approval of COC, as I mentioned, that the related party transaction, then we entered into a common overhead agreements where the common pool or back office was supporting operations of both the companies. So all arm's length issues we have catered to and executed. But now then the subsidiary defaulted on that payment which was required to be made under this common overhead, because there were common overhead on account of common team which was supporting the operations of both the companies. So we arrived at some scientific formula and we agreed. Now they defaulted. Now what happens? They defaulted. Now when they defaulted, there are consequences, because the resources which are on our payroll were using, so subsidiary was using the services. So there was a dispute on that. We tried to convince this common team which was supporting operations of the both, that you should avoid supporting them, or rather you help convincing the directors that this is limited or minimal share. If that's been provided, the value of both the company remains intact. But somehow that couldn't happen, and that led to a situation where, because of promoters' ego, what he did is that we had overall strength of the holding company of some 500 employees, and out of which operations were, the core operational guy was 400, and 100 was complete back office, which includes account, finance, purchase, your design, and various other departments. So one fine day, some 81 people out of this 100 design, and we had to now think of what we do to basically keep the operations on, because the entire backbone has been taken away from RP, with the purpose to make sure that it is not you who is in control, or we are not taking away, I mean, these employees are still mine, and that sort of effort by the promoter. But finally we had to take certain actions and make sure that those team are revived. Now that definitely leads to a constant update and the approval of COC, because one hand you are handling a firefighting situation where you have to have that presence of employees across, and wherever there are critical gaps, you have to appoint. So in that situation, we went to COC. We had a detailed project plan for entire organization. We took an in-principle approval with the budgets. And when the recruitment started, there was a periodical update because, see, in a company, again, for the companies like where you are having a regular turnover, because there are industries where if the company is operational, every month there will be certain people who will be resigning, and every month you will be recruiting some people. So again, we have fixed some understanding with the COC that every COC we have that approvals in place so that we are adhering to the provision of Section 28. But see, from the normal process, so where there is no enough turnover or there are hardly any employees, it's fine. But an operational company, this becomes an additional task for RP to make sure that you do that. Same goes with your appointment of auditors. Now you may continue for some time and then auditors are not willing, or for whatever reasons they are not comfortable. Now that's also something which we have to take care of, mainly because operating company. Now operating company audit itself is a different task. See, if it is a company which is not operation, it's fine. But if it's an operative company, to getting the audit done, compliance done, everything becomes an additional burden on the RP. But again, when it is operational, there are employees who are supporting the entire thing. But you as a RP has its own risk, which has to be also mitigated or basically covered under those audit reports. I mean, the financial statements, and indirectly reflected through those audit reports. So all those things which are required and critical becomes more burdensome when it is an operational or a going concern company. And there are basically mitigation tactics, which measures which you have to take. But yes, this becomes a very critical aspect when handling the going concern. So with that, we have covered all the operational issues per se. But just to give you a glimpse of, basically, for me personally, what I feel is, and that varies from case to case, that, planning for resources for the RP becomes very critical and a very meticulous task for a type 1 company. See, for type 2 and type 3, you can have a common team because, see, I'll tell you what happens. I have divided the entire major task into 3 major buckets. Now, for any company or any corporate debtor which is into CRP, you have first and foremost is the custody control, cash flow and operations. Statutory compliance is applicable to CD, which includes industry related licenses and other related stuff, and your regular statutory dues related compliances. Second major bucket of tasks which RP has to do is basically core process related activities, which includes your transaction audit, valuation, entire bid process, COC meetings, agenda, minutes, voting, all those nitty-gritties, IP and IPBI compliances. And the third set of things is litigation. Why I have carved out a separate litigation is because this is something which, along with operation, or this requires a complete dedication or a separate address. This has to be addressed separately, independently, and professionally. So that's why I have created 3 buckets of the major tasks which a normal RP or IRP has to take care of during the CRP. For type 1 company. So I personally believe that the team, if the cash flow and the COC allows you, ideally you should have a separate, independent, dedicated team, if required, with the experts who will be exclusively looking into cash flow, operation, and related aspects rather than merging it with the CRP related activities. There can be correlation and interarrangement with the company, with the team, but ideally there has to be a separate team. And same goes with the process related activities, because what happens, the operations are there, but that's not the core. As a RP, your core is the process related activity which has to be done in a timely manner. So having said that, same way litigation, because other than your NCLT, NCLAT, LC, Supreme Court related litigations, you have to handle litigation relating to commercial disputes which are arising out of the normal operation of the company. So here also maybe some expert professional help or some lawyer. So I believe that type 1, you have to create those Chinese walls, or basically best possible bifurcation among the team members, which is utmost critical. Type 2, type 3, you may have overlapping responsibilities and duties, but this is just for for a reference for you. We are having this session where we are focusing on going concern, so this becomes a point which is critical. And the next one slide, which is again a very generic slide, but what I believe is that preparation of for the type 1 companies assignments vis-a-vis type 2 and type 3 assignments are also require a specific and a different approach. So generally what happens that for mainly type 2 companies, understanding of the business prior to initiation or after you give the consent becomes very critical. You have to have basic understanding. You have to have the operations, locations, litigation, non-compliances, general searches, ROC searches being placed. See, you don't know as a IRP or RP, you don't know when the case will be admitted. But you have to have this preparation because if the company is operational, it is very difficult for you to carry both the responsibility. So that's why I'll go back to that earlier table where you have multiple core tasks which has to go in parallel. So the preparation becomes very critical for you. Now, day 1 to day 30 is more or less common for all, but then operational companies take an additional toll on, or rather, it adds to an additional responsibility on RP to make sure that the custody control and the cash flow control is there for this company. Because if that is not achieved, ultimately sooner or later the lapses and the risk which will increase for the RP, though he may be basically completing and doing all the related tasks which are process related, be it appointment of valuers or basically public announcement, Form G, whatever it is. So process wise, I think RPs are way sorted, but operational companies adds to an additional burden on RP to make sure that proper controls are in place, which is first 1 to 30 days. Now, why I'm harping on this period is 30 days are something where for an operational company, type 1 companies, you have to be on a ground, you have to be on various other aspects, and that requires a complete different focus. Now, see, that depends on the type of IP or support you may have, but across type of or nature of assignments or the size of company, if it is operational, you have to have that different approach in place. And from day 30 to 180, I think by the time if you have completed the task which is initially been covered, then I think you have more or less sorted the things, and there's not much which may be basically required, or which is basically then you are basically on your own with the flow. Here also, again, going back to the team part, sorry, I missed that part. The optimizing or utilizing the team of CD becomes very critical, because that's where you get maximum support. And if the cash flows permits and you are honoring to their commitments, or other corporate debtors commitment towards them, I think this becomes a slightly easy part, except that loyalty factor. But utilizing the maximum of CD team also will help you, provided the comfort of, the loyalty part or loyalty factor, how you mitigate or how you deal with this. But utilizing the team of corporate debtor also becomes very vital for our operational company as an incoming IRP and RP. So this is just a brief on. So with that, we have completed the first session on the operational part or practical difficulties of handling an operational company vis-a-vis and partly completed or a non-operational company. So if the team wants, we can break for 5 or 10 minutes, and then we can continue the session, because in the second session we are briefly covering on implementation of the plan and the few case laws which I find it mainly from the going concern and the operating company which are critical. So that we are going to quickly cover. So if you guys are in confirmation, we can take a break or we can continue. So it's up to team.
So we can take break, I think.
So let's take a sharp break of 10 minutes and we'll be back. So
Right, sir, right.
so we can quickly take a break of 10 minutes. I'll be back in 10 minutes and I'll start immediately after that. Yeah. Thank you.
No voice. Is the meeting continuing? Anybody there?
So maybe they have a break. They have a break.
I see. Okay.
Sir, there is a 10 minutes tea break.
Yeah, we can start if participants are present.
Sir, we should start.
All right. Thank you. So in the second session, as I discussed at the beginning, that I'll be covering implementation of the resolution plan, managing committee, role of a monitoring committee, and pertinent aspects in relation to the implementation of resolution plan. So again, here I have a very, very brief presentation on key aspects. But having said that, considering the different experience, my personal experience in different implementation and learnings in my past resolutions, I have summarized some of the key points and legally as well as otherwise how this particular aspect of this process, which is not been clearly defined under the law, because the implementation is something which starts after the end of moratorium. With the end of moratorium order and approval of resolution plan order, the roles and responsibility of RP also ends. Effectively, there is no committee of creditors. They are now again financial creditors. Now, as per the typical resolution plan, you have the structure of the committee which will be basically acting, and they are basically made in charge of making sure that the resolution plan which has been made approved by COC and NCLT, adjudicating authority, is implemented and related provisions. So I'll be taking you through the one by one aspects in relation to that, and we'll concluding with the key action points for the implementation of the resolution plan. And after that, we'll be quickly taking up the case notes. So as I mentioned that, the entire process of implementation basically starts, as I mentioned, with the approval of the resolution plan by NCLT. Having said that, there are legal provision which specifically stipulates the requirement and need of implementation and supervision of the resolution plan. So as per section 30, clause 2, subclause C and D, there basically it is the duty of resolution plan to examine the resolution plan, whether basically it is having and confirm that plan provides for the management of the affairs of the corporate debtor after the approval of the plan, and D, the implementation of the implementation and the supervision of the resolution plan. Now, why I have chosen C is ideally because once your plan is approved, now it is basically taking over by the management, and that is there. That is basically a successful resolution applicant will be doing it. But the entire process is basically is of two phases. One is basically a period between the approval of the resolution plan by the adjudicating authority until there is a formal handover and takeover of the operations by the SRA, successful resolution applicant, and the management after that. Because once in between, basically, so there are two stages. One is the up to period of transfer. There will be basically there has to be a mechanism which will be operating, because the risk of non-implementation is there. Risk of basically non-payment or not providing or not taking action which are required by both the stakeholders, be it committee of creditors or be it successful resolution applicant. That risk is there, and that's why there is an interim management, and then there is basically a final management change as defined under the plan. So it is a duty first on the RP. Further, the duty again further has been on the adjudicating authority at the time of approval, that they have to make sure that it satisfies the resolution plan, satisfied that the resolution plan has been has provisions of effective implementation. So it's basically three stage where RP is duty bound. The same plan will be further reviewed and finalized and approved by the COC. Third, the adjudicating authority also has to make sure that there is enough provisions for effective implementation of the resolution plan. And there is a regulation which also basically contains that, a mandatory content of any resolution plan, which again justifies, stipulate the same thing, then the adequate means for supervising its implementation. So this is where the requirement of implementation and monitoring of the plan has been created under the law. And now let's understand why the implementation and monitoring is critical, what is there at stake, and how it's basically, is generally being taken care of by. Because these are the only provisions under the law which deal with the post-approval of the plan by the NCLT. There are no further guidance, no regulation, nothing with respect to the implementation of the resolution plan. Now let's come to this, why you basically, need monitoring. So let's understand, for committee of creditors who have basically, approved the plan. Now, the plan is a Bible. It is a document which provides for the settlement of dues as, or rather settlement of the claims as, and along with the CRP cost as put up and compiled by the RP. So for the committee of creditors, basically the payment or the settlement under the resolution plan becomes a very vital aspect upon approval. And that is where they are connected. So as far as the secured creditors are concerned, the no payment, if there is no payment, no release of security. So that remains a critical part, along with the other creditors where they are also expecting now, there has to be basically honoring acknowledgement and the the payments which are committed by the SRA has to be honored. Now on the other side, once upon the approval of the plan, RP becomes erstwhile RP. But what will happen in this entire process is that RP was in charge through COC of the COC. So effectively, if you see the entire operations, all related aspects were controlled, or the RP was made responsible for that, being acting as a decision maker, signing authority, also basically registered with the statutory authority as an authorized person of the corporate debtor. So immediately with the order, all of a sudden there is a full stop to the RPs. But the stakeholders doesn't operate or work that. So be it banks, be it your statutory authorities or various authorities, it doesn't operate that. They basically need a decision, they need a guidance that how the RP will be replaced during the process. Also, basically, this also leads, so the law doesn't provide any role of RP after the conclusion of process, but by default, the way processes are designed, the RP has to, I am not saying for the period, the quantum I am not commenting on, but RP's continuation has to be there for some period. If not, there is a provision under the law where once the resolution plan is approved, the RP is required to intimate all the claimants and stakeholders in relation to the approval of the plan. Now, for that reason also, and for handover, because the RP was the one who was in charge, COC was not the one who was in charge of these operations. So there has to be a formal handover of the operations and all those actions, all those places where the RP is acting on behalf of corporate debtor. So there has to be replacement of that. So for that very reason, irrespective of the fact that the RP's role has ended, moratorium has ended, RP has to continue for some time. Now let's come to the resolution applicant. Now let's understand from the resolution applicant's point of view. Now, till the time COC approved the plan was basically a document which is yet to be approved by COC and NCLT or adjudicating. So from the RS point of view, except the performance bank guarantee along with the plan which he has committed, there is nothing at the risk. But upon the approval, there is an anxiety, there is a risk, there is a clock which is now ticking of the action for the actions which he has committed under the plan, and that has to be completed within that stipulated time. So there is an anxiety. Why I said the anxiety is basically now it is SRA, successful resolution applicant, to perform, and he has also a daunting task of taking over the entire operations assets of the company, because till the time he was not engaged, except those limited due diligence, limited visits, and understanding of the corporate debtor and the data room, he was not exposed to the actual assets, actual operations, actual things which have happened during CIRP and pre-CIRP with the corporate debtor. So that's when now that period has started where he has to start working on all these aspects. Now it starts with, as typical plan envisage, the related ROC filings for change in directors, change in capital structures, change in issue of new capital, cancellation of erstwhile capital, apply for or renew for some statutory licenses which are expired, approvals, government statutory approvals, registration, preparation for restructured financial statements. Now this again, because these are all very critical aspect for him, because as on takeover date, he has to basically make sure that this is the position of financial corporate debtor, and this is what he is taking over. Now taking control of the operations in general also, as we covered under the earlier also, type 1, type 2, type 3, irrespective of the entity. The kind of preparation which is required may vary from the type of entity, but yes, now it's the time for him to act. And that's where the role of monitoring committee comes into picture. So now let's understand as I mentioned, which are the two major phases where the monitoring committee issue come into play. So typically, as per the best evolved practices, in the resolution plan itself, there is a structure of the monitoring committee which has been defined during the deliberation and discussion on the resolution plan, along with the other commercial and the other legal aspects of the plan. So this is where basically structure has been finalized, and as part of the final plan which has been put to vote and approved by the NCLT, COC and NCLT, the structure. So the typical monitoring committee will have representation from the successful resolution applicant. They will have representation from the COC, and in some of the cases where they have been also mentioning about some agency, outside agency, or the erstwhile RP being voting or non-voting members. So there are voting members, there are non-voting members, but the representation more or less remains within this whole thing. So COC basically, naturally, where COCs are of large numbers, large members, they in turn nominate the members who will be acting as part of this committee. And SRA naturally will be also nominating their representation to the committee, and RP if required. Now, especially for the RP, now there was a judgment in case of IP Mahendra Khandelwal ji. There, basically, the discipline committee has put a bar on RP acting as a monitoring committee agent after the approval of resolution plan, and the main grounds are two. One is that RP cannot take up anything in relation to the corporate debtor immediately within the 12 months. Before expiry of 12 months from the approval of plan. And the second ground was that the payment, if at all, if the RP services are availed, if the committee in turn is designing, but the payment is effectively made by the resolution applicant only, which basically, not in line with the code of conduct of the act. And that was a judgment which came and which created confusion in lots of the processes. Because till that time, as I mentioned, that the role of RP and the role of, the kind of engagement he has, or rather involvement he has with the operations and the other aspects of the corporate debtor is huge. So it is very obvious that the RP will continue as part of committee. But after this judgment, the judgment put a question mark on whether the RP should continue or not. And various processes, various resolution plan are now factoring it differently. So many of places I have seen that the RPs are acting as a monitoring agent, as a non-voting member, and without any remuneration. So that's one part of it. Apart from that, basically, they are engaging with the other agencies or other IPs or other agencies who have been acting as a support entity to the RP. So all those different practices are evolving, but there is no fixed setup where basically, this is fixed that RP will be part of it or not part of it. Considering this judgment, it is in the interest of all the RPs to avoid taking any active role or basically, role with the remuneration in the monitoring committee. But as I said, that the RP's role was so critical, somewhere all the committee members and this at times statutory, adjudicating authority has also put in and mentioned as part of their order that the erstwhile RP will continue acting as a monitoring agent or one of the member of the monitoring committee, and he is duty bound to submit a regular status report. So, considering this Mahendra Khandelwalji's judgment, that has created an embargo. Otherwise, and we had, personally, I have also had a multiple representation with IBBI and all. But now IBBI is of the view that you have to create or work out some innovative solutions, because you being RP cannot continue. That is their firm stand. So we have been representing, I have been also representing, but there's a separate issue. Let's park it separately. But let's understand academically what is the role and how basically, this entire function or rather this phase has been put to operation. So first phase, as I mentioned, is that from the date, that is nothing but an or date on which the order was order for the approval of resolution plan was pronounced, till the formal takeover by the resolution applicant and successful resolution applicant. So here the management is basically with the monitoring committee, lies with the monitoring committee. Now there has to be meetings of the monitoring committee. Monitoring committee has to take all the actions in relation to implementation, making sure it's timely completion, and upon conclusion of the actions which are mentioned under the resolution plan, the monitoring committee gets dissolved. Now, which are the actions which are basically, are being operated or are being carried out by the monitoring committees? One is basically working on the operations handover, because monitoring committee has to now prepare for the handover, because the RA is a independent, or till the time it is approved, it was a neutral or had a limited exposure to the corporate debtor assets, operations, and structures. So that's the biggest process which has to initiate immediately after the order. Second is, again, mammoth task is in relation to the CRP cost and the claim disbursement. Now, here what happens is that the RA has proposed claim settlement as well as the CRP cost. But now there is an inherent uncertainty over the date on which the resolution plan will be approved at the time of filing. So there has to be basically a detailed reworking of the CRP cost has to be carried out. The CRP cost has to be worked out and finalized up to the date of approval, and the preparation for claim disbursement. So now, as part of the best practices, what generally RPs or basically monitoring committees are doing is that they, along with the communication for the approval of resolution plan as required under the law, they also basically reconfirm that this was your claim amount, this is the settlement amount, and these are the bank details Because typically many year processes, what happens is that the processes are prolonged so much that by the time the resolution plan is being approved, it's almost more than 1.5 years. So then there are various probabilities or changes which may have affected the status of the claimant, being their bank account or their legal status or their entity or various other things, maybe because of death or various other issues. So it is in the interest of process that when you are ready to implement the plan, at least you have this communication in place and you are reconfirming. So under law, there is no requirement of reconfirmation of the bank account, but it is better in the process, interest of the process, that you get this reconfirmed or convey to them that this was your claim, this was your accepted settlement. I mean, this was the settlement which has been approved, proposed by the SRA. And third is basically bank account details and other relevant details. So this is the communication which has to again go. So this related and the disbursement part. So again, so disbursement is basically the fund will be infused. So the accepted practices are where the funds are infused in the accounts of corporate debtor. From there, the disbursement happens in relation to the CRP cost, and in the order of section 53, the disbursement has to happen. And accordingly, the committee decides that who will be the signing authority and who will be the disbursing the payment. So that's how the disbursement happens. But for that, a lot of preparation and the finalization is required. Ongoing operations. Now, again, this adds to an additional burden on the committee, because when there is ongoing operations, because now RP is no longer operational, COC is no more there. So there has to be basically, decisions in relation to ongoing operation which has to be taken. So there has to be regular meeting of the committee, wherein apart from the implementation related steps, they also basically take decisions, being authorizing somebody for the cash flows, other related operations, authority in relation to filing or complying with the statutory requirements, compliances. So all those things have to be discussed, again approved at the monitoring committee level, so that till the time there is a formal order, the corporate debtor is not at loss. Because in worst case scenario, if the plan fails, the status of the corporate debtor has to be maintained. It can't be basically, because of this approval of the plan, it will be like, it should not be a situation in no man's land where nobody is responsible and ultimately the stakeholders are losing value. So for that very reason, the ongoing operation also has to be, and along with the statutory compliances have to be there. I mean, taken care of. Convening meeting, as I mentioned, that it has to happen to decide on the timeline and the triggers under the resolution plan for the payments and other related aspects, as well as the operation related issues which are required to be taken care of. Application to the authorities in relation to the resolution plan. So typical resolution plan have some government approvals, concession, clearances. So all those applications are basically, are the SRA. So successful resolution are expecting that they should start. This is basically a very, I would not say lengthy process, but it is a process which requires diligence and a proper decision at the monitoring committee level, so that this becomes easy and SRA also basically, achieves the benefit. Because it should not happen that, if you are not putting in money, nothing will start, no handover, nothing will happen. So there has to be comfort and understanding which has to be built at the committee level between SRA and COC, that these are the tasks which has to be completed or which has to be initiated. Not even if not completed, but has to be initiated for the proper turnaround of the operations. So that is something which has to be taken care of. Status report. So typically in nowadays, I'm seeing it in many orders approving the resolution plan, that the committee or the RP, as the case may be, is required to update the NCLT on the implementation of the resolution plan by way of a status report. This is an additional practice which has evolved over this period. So that is something which has to be done. Now, again, the last is basically, second last is a worst case scenario, when if the plan as envisaged under the as per the resolution plan, if it's not been implemented, then there has to be basically a committee or representative of COC who has to update the stakeholders, so that appropriate action can be taken or something can be decided to make it operational, or basically other action can be initiated in a timely manner if there are defaults from the SRA part. Timely handing over the operation CD upon the completion of commitment under the plan. So again, preparation of handover, but timely handover also is something which is monitoring committee's task. Now, what is the duty of SRA? Now, during this phase, though he is acting as a monitoring committee member, but apart from that, there are specific tasks which he has to make. His first is basically timely infusion of funds if all the milestones have been achieved. Now, there are two type of resolution plan generally a process will receive, which basically further go for a COC and NCLT's approval. One is upfront plan, where SRA or rather resolution applicant is committing that the payment towards ERP costs and the claims will be infused within say stipulated timeline, and after release of that payment or rather making those payments, the company will be handed over to the SRA. So that's basically more or less an upfront kind of a plan where 60 days, 90 days, 120 days, as the case may be, the SRA puts proposes, and upon approval of the plan and upon achieving or this milestone of timeline and infusion of fund, they become the owner as well as the in charge of the corporate debtor. So here, wherever there are time limits which are mentioned under the plan which has been approved, the timely infusion of fund is basically a duty of SRA, because many a times what happens that there are different requirements, or there are various internal things which SRA has to complete before the funds are infused in corporate debtors account for the payment of claims and CRP costs. And there are basically at times complications or the unforeseen circumstances because of which the SRA delays the payment. So that's the reason why SRA also should be made responsible after the resolution plan. So though the plan is Bible and plan is something which is applicable to all stakeholders, but still, this is something which is expected from them and they should honor it. Second is extension of PBG. Many times what happens that you receive a performance bank guarantee at the time of resolution plan. But at times that because of various reasons, be it prolonged litigation in approval of resolution plan, or after approval of the plan by the NCLT, there is a delay in implementation. So what happens? The PBG, a performance bank guarantee, which is a security given by SRA to the stakeholders, that if they fail in their commitment, their bank will honor some ballpark number which has been submitted as a performance bank guarantee. Now, we have seen that typically the tenure for which these PGs are created is 6 months to 1 year, 1.5 years, as the case may be. But by the time this plan or the infusion of fund or the implementation happens, these BGs are tend to expire. So again, SRA has to made aware at a regular interval that you have to extend the BG, keeping in line with the approval date and the implementation date, as the case may be. But that if the PBGs are getting expired, it is a duty of SRA to get it extended. So that is something which SRA has to take, except in the responsibility to handle limitation initiated before and during ICDs. Not limitation, it's litigation. So again, this is very critical aspects. What happens that RP is now relieved, but many a times there are various litigations which are pending, be it transaction audit related part, which more or less in nowadays in resolution plan it is being considered that the COC will be taking care of it. So that's apart from that, there are various other litigations or commercial or disputes, which wherever in case of after initiation of CRP, RP may have declared him as an authorized representative and filed, or basically representing the corporate debtor. Now, what happens after the conclusion of CRP? The RP or the COC, as the case may be, are still made party and part of the communication in relation to these disputes and litigations. Now, it is the duty of SRA, and the committee has to make sure that the SRA takes the responsibility and make sure that the relevant filings are made before the various adjudicating authority or the authority which is adjudicating that respective matter or arbitration or the statutory authority. That now upon the completion of the plan, the SRA will be the one who will be representing it. A limited undertaking or statement has to be issued by SRA to the COC and the RP, outgoing RP, that henceforth you are not requested to, RA will be taking care of all this litigation, because I have seen in many places, many things, including that NCLAT or Supreme Court level, there are applications are being filed in the name of RP. So RP still is becoming the respondent. Without having clarity on this part, there is still an engagement of RP in these type of litigation, which is unwarranted once the resolution plan is implemented. So for that limited reason also, the SRA should take the responsibility of handling this litigation, and the RP and the monitoring committee has to duly document it. Now, as far as the COCs are concerned, the mammoth task with the COC member or all the financial creditor, because COC is no longer there, is to make sure that upon the settlement, they are issuing NOC or no due certificate to the SRA that their dues as per the plan are settled. Second is, in case of a secured creditors, there is a proper release of charge and handing over the original title documents to the SRA. Now, this particular aspect in many of the processes we have seen this always delayed. So most of the cases, the COC members are pushing it that you first you infuse the fund, then only we will release this and all. And effectively, upon release of that payment, they effectively start the process of getting this done or getting these internal clearances for the NOC and release of charge. Now, that is something which is not right on the part of a COC member also, because see, SRA, if they have honored their commitment, they have not defaulted, it is equally binding on the COC member to also make sure that they also honor their commitment. But this is something which has not been taken care of by various COC members. So as I mentioned about that first type of plan, where the let me go back to the type of plan. So the first phase is basically getting over with the type of plan which are only having the upfront payment. Now let's go to the second phase. Now the second phase is nothing but in case the resolution plan has a provision of some upfront payment and some deferred element or deferred settlement. So in that case, the monitoring has to continue, because effectively the plan has not been implemented completely. In most of the cases, the management has been taken over by them. Management has been handed over to the SRA, but the commitment under the resolution plan still remains with the SRA. So that's where the in those cases or in those resolution plans where there is a provision of deferred payment is there, the second phase will become applicable. Now in this phase, which is nothing but after takeover of the operations and the corporate debtor by the SRA, till the implementation or the honoring the final commitment under the resolution plan. So this is the tenure, which is large at times, or more than 1 year at times, or rather majority times wherever there is a deferred element. Now here it is becoming more difficult, or rather more critical for the committee to make sure that they are making sure that this is something which has been properly represented, and they are aware that what is happening into the corporate debtor, so that they have the surety and assurance of the commitment which has been made under the plan by way of a deferred payment or deferred commitments are honored. So that's why the monitoring committee in those cases will continue with a limited power, because now the management has been transferred in favor of SRA. So those responsibilities are not there, but still the implementation responsibilities are there. So here, many a times, what happens is that there are deferred payments. So this committee has to make sure that there is a meeting of the committee at a regular interval to update and to get an update from the SRA on the milestone of the under the resolution plan, disbursement of the milestone based related payments or otherwise any related payments, because I've seen in many of some of the resolution plans. So in my case, in one of my case where the plan is of so there was basically a PC company where they had proposed an upfront payment settlement for the fund based payment, and there were live bank guarantees worth of 500 crores. So what they had proposed is that RA has proposed that I'll make sure, because there is still an open exposure to the bankers. Live bank guarantees are still an exposure to the bankers. So RA has proposed under the plan that they will be relieving or bankers from this bank guarantee. So this bank guarantee will be relieved by putting in efforts or by basically completing the commitment under the respective contract against which the bank guarantees has been issued by the bankers over in the staggered manner. So they had put in a period of 3.5 years, where in the first year they will be trying to release some 100 crore worth of bank guarantee and so on and so forth. So it was basically triggered where the payments were not linked. There were no deferred payments, but there were basically a release of this bank guarantee by the SRA was committed, and they have to take care of. So that's why understanding the progress on the project also becomes very critical, because these type of contracts where there are commitment from the corporate debtor, and now because of the management of the corporate debtors with the RA, if they don't honor, there is a risk of bank guarantee being invoked and the banker's exposure being converted into fund base. So though under the plan which I am talking about has a provision of separate FD being created to compensate if any invocation happens, but still the monitoring is required during this period till the time the last bank guarantee is being returned to the respective bankers by the RA through their customers. So based on the contracts, but the monitoring becomes a very critical part. Now here also the duty of SRA is to timely updating the monitoring committee on the revival of CD and financial positions. Honoring commitment under the plan is milestone, because more or less now it's only duty of SRA to make sure that the balance part of the plan is being implemented. Now COC is basically now monitoring and implementation of the resolution being active erstwhile members of COC. So now the representation is there. Now COC per se doesn't have, but in many cases, in case of deferred also, what happens is I have seen the plan where the management or handover has happened, but wherever there are deferred payment or staggered payment under the plan, which are going beyond certain period, so then COC also stage it along with the release of security. So what happens that, just for a layman, that if there is a plan of 100 crore, 50 crore to be paid upfront, and the 50 crore will be paid in deferred. So say after 2 years. So typically in the resolution plan itself, the COC has put in, or as part of the negotiation, they put in a condition that upon release of 50 crore, you will get X security or zero security, only get a management control. And upon release of balance 50 crore, you will get a security release. So for them also now it is equally critical, like the earlier stage, that if there are any security release or any commitment by the COC members to the RA upon the triggered payment, so that has to also be released by the COC. So that is something also which is equally critical for the COC members to take care. So in short, this is the nutshell of the overall monitoring committee and implementation of the plan. Now I'll take you to the practically which are the critical things, which are basically very important aspects, and how it is to be taken care of. So as I mentioned that ideally on a best as a best case practice, just a minute, how one should be handling. So once if you are a part of we are a RP and there is a COC, so typically there are two periods or rather two trigger or events which are critical to plan for this implementation, because what generally has been observed, particularly in my case, is that after or rather at the time of finalization or the negotiation of the resolution plan, many a times certain situations are not envisaged or not planned, which when you trigger or when you actually enter into implementation stage, you come across. And at that time, it becomes difficult because those situations are not properly envisaged or documented. So for the stakeholders like COC or any other stakeholders who are getting impacted by that, it becomes weird. It can be SRA also. So then at the time of plan itself, the implementation stage has to be properly defined so that when you actually trigger that event or rather of approval of the plan, the roles, responsibility, or basically these are the points which are defined. So just to name a few, that the plan itself, if the time permits or the COC agrees and the RA agrees, these are the points which should be basically should be incorporated under the resolution plan only. So first is basically constitution of committee, monitoring committee along with the chairman. See, constitution of committee is always there, but many a times this constitution is silent on the who will be the chairman, who will be convening monitoring committee and meetings. Because see, if you don't have defined the chairman, at times it becomes practically difficult to that who will be convening meeting, who will be then finalizing the meeting and agenda. These are all small silly points, but then it becomes difficult at the time when you actually entered into, and then if you give responsibility to RA, then COC members at times feel that this is not required, or why they should prepare it, they don't have control. So all those confusion arises. So it is better to have a proper roles and responsibility defined. Again, second is the same point, that define the roles and responsibility of COC members who are acting as a nominee members of as a monitoring committee, RP if at all, if it's there as a non-voting member or as the case may be, and the SRA during the implementation. So here also the roles and responsibility which I covered in the earlier slide, if they are defined in a properly manner. So though, see, right now it is too theoretical for you to understand, but these are all things becomes practically challenging when we actually enter into a space, because there are so many small things which, for example, opening up of a new account. Now SRA wants to open a new account, but if it is not defined, if it's defined, then it becomes easy. You can see the account will be opened, the signing authority will be SRA or the COC representatives or RP as the case may be, but it becomes practically possible to do that if it is documented. Otherwise, it becomes more of a discretionary nature, where some of the stakeholders may feel that we are aggrieved by the kind of conduct of the committee. So just to avoid that, again, clauses in relation to PUFE transaction in use of excess cash flow with the CD. So ideally, this should be part of your RFRP only. But if it is not covered under RFRP, at least this is again a second chance which you get to define that who will be the beneficiary of a PUFE transaction if it is not concluded before the approval of the plan, and what happens to the excess cash flow which has been generated in case of operating or available of cash flow. What will happen to that if it is not properly defined under the resolution plan? Again, the responsibility of handling ongoing litigation and the relevant cost during the implementation phase. Now, this also becomes a very critical phase, because litigation will continue, but the cost during this period is not a CRP cost. So cost has to be borne by someone. Now, someone is basically nothing but an SRA, but whether SRA is comfortable in handling this cost, because if it is documented at the part of resolution plan, it's okay. Otherwise, what will happen? Once you basically start, because the company is on, the costs are being regularly incurred on various aspects, not only on the litigation. But if it is not, in principle agreed, it becomes difficult for SRA also to, commit or overcommit at the implementation stage. So that is something also I believe that should be covered under the plan. Responsibility of finalization of financial statements, statutory compliance is drawn till approval date, transfer date, and as the case may be. So again, financial statements are something which is very critical for SRA, not very critical for outgoing RP and COC. But this creates a problem. Now, how it creates a problem is that many a times SRA wants that financial statement are finalized before they infuse the fund. Now, if it is not properly defined under the resolution plan, now that creates because that creates an issue of what I can say, it's a dispute. But because what happens, the COC members want some money if the condition has not been mentioned for finalization account. Now, what happens for the SRA? Now, understand that because he is taking over the company first time. Till the time, whatever has been done by the RP and COC, the transaction are though recorded, not recorded, whatever must have happened. But now, the financial statement has to be drawn because he has to basically take over and restructure the balance sheet as on that date. So for SRA, it becomes very critical. But if it is not defined that who will be finalizing, who will be signing, I have seen the issues of who will be signing the financial statement because the RP is out. So RP cannot sign. COC will never sign. So who will sign? SRA at times are not comfortable. Existing director will which was not signed. So these are the small nitty-gritties if been taken care of, which really helps at the time of implementation stage. Again, the approval of cost to be incurred during the monitoring period. As I mentioned that, at times there is a cost which is incurred, not only for that, but there are professionals which are engaged and regular operational cost. So both has to be then, at plan stage, at least you define that these are basically, additional thing which will be responsibility. And at the actual time when you are into that implementation phase, you can decide how it is to be taken care of. So that is another thing. List of document to be handed over to SRA upon implementation. Now this becomes a very, very difficult task practically. Now what has happened, I've seen in many cases, RPs are having records, but RP has its own limitation with respect to records. Now you prepare a list of records, but SRA comes up with a different requirement. And that is something which is discussed at the time or just a trigger date or just before trigger date, let's see, we have written in this that the formal handover has been given, has to be given, and they give the detailed list at that time. So these are the list of documents and the details which you want. Now that is something which is practically not possible for our erstwhile RP or COC to do it, because this is a special situation. Had it been, it has been communicated earlier. Had it been at the time of approval of the plan, or rather finalization of plan by the COC, RP and the RA, if they are aligned on this part, then it is okay, because then at that time RP also has a chance or opportunity to explain the difficulties which they have and the availability of information. Because though the data room is the final basis which they plan, so plan is binding on them, but practically when they come to this stage of implementation or putting in money, actually bringing in money, these are the issues which are they generally raise. So that is something which has to be then taken care of at the time of finalizing plan only, so that it avoids the confusion at later date. So list of documents to be handed over should be defined, and undertaking of discharging the erstwhile RP from all the responsibilities and COC from all the litigations and stakeholders. So again, this, if it has been factored under this resolution plan, it actually saves a lot, because what happens after if that is not defined under the resolution plan, at times the RA says that we don't know, we are also let the RP respond, we will support in the cost and all, but that's not a very warranted or a comfortable situation for COC or RP, that any litigation keeps on coming for n number of years in relation to CD, and the RP and COC are made party to it, which is not logical once upon the conclusion of the process. But if it is not defined, stakeholders tend to take leeway of that, so it has to be then properly taken care of. Reconfirmation of details, I think there's some typo here, so I must be preparing, but I don't know, I could not complete it. So be it. So going to the next part of preparation. Again, see what happens. Approval of plan by NCLT till transfer date. But before that, there is a phase. Let me tell you what happens that if by chance, if the part A issues which are not covered or defined under the plan, ideally what one should do as a RP, because in some of the cases this has helped when this were not defined, because we also evolved, we learned with actual implementation. So there is a time period between the approval of the COC and the final approval of NCLT, which is by and far we know that how much minimum time will be required. So that period also can be utilized to iron out these issues among the stakeholders. So many a times, say for example, there was an environment clearance in one of our case. That environment clearance was getting expired, or rather was expired after the COC approved the plan. And the RA wanted that, this is a very critical thing, because if they have to revive the operations, the first thing what they need is the EC clearance. Now, if they want EC, then there has to be a formal application. Now, there were various other guidelines, issues, and which they had to follow. Now, practically, the money has not come. The plan has not been approved by NCLT. But still, in those scenarios, what as a stakeholders, we as a RP and the stakeholders, we sat around, we worked out that what is critical, and what is critical in terms of even if the plan is not approved, what is still critical from the value maximization point of view and the value of the corporate debtors point of view is critical. Let's do that. So we could arrive at a list of action which can be initiated by RP, which can be further taken care of by RA when they formally take over. But at least there is an action which is initiated which saves the time for RA, because NCLT at times we don't know how much time they will take. But that should not be the reason for RA to suffer if it is convenient and practical to initiate those steps. So the period between COC approval and NCLT approval should be utilized for all these ironing out these nitty-gritties, so that transition becomes easy and the RA is in position to revive the company as early as possible. The second stage, as I mentioned, that approval of plan by NCLT till transfer date. So again, the additional duty which one has to, as a RP or a committee, one has to do is all action point over. If not covered at the first stage, then you don't have choice but to do it at the part B stage. A submission of progress report with the AA, and to make sure that the plan has been properly implemented, and updating stakeholders on the milestone already achieved and pending action under the plan. Now, see here, the law is completely silent. Now, what happens that the RA is supposed to infuse fund in say X days. RA has not infused, but it's not only the committee, it's the COC members or other financial creditors, operational creditors, all the vendors who are impacted by this. So at least critical stakeholders should be intimated that the plan's implementation will be deferred on a need base. But that has to be done. You cannot basically, as a committee, you cannot basically decide and sit on something where the larger stakes are involved. So somewhere said that sort of line of communication has to be created during this period, and it has to pass on to the beneficiary of the resolution plan. Third is approval of plan by NCLT within transfer date. So again, submission of progress report with AA, updating stakeholders on milestone already achieved. So this remains the same, but last what I have added is basically in case the plan is not implemented, then what you do basically, then there has to be basically an action which is required under the law. So there's an application under section 33 which is required. So that has to be filed. So this is on the implementation of the resolution plan. So that I have covered briefly. Now I'll just quickly touch upon, rather than taking up all the case laws, I'll quickly take up on the critical case laws, which I believe is, so this is not short. I'm not an expert in legal, to be very honest, but basis my understanding on the operation heavy corporate debtors or companies, some of the dues or some of the issues become so critical, then whether NCLT or how the law can come at your rescue is something which is critical. So that's why I've tried to cover something, not everything, but which can basically, just to add value to the entire topic. So yeah, so this was the first judgment is of GUBNL versus Amit Gupta and others. It was basically a Supreme Court judgment wherein it's a very peculiar case. The company was into power generation. The company had a PPA with state government. The state government, after the initiation of CIRP, cancelled the PPA. So the whole issue was that whether this cancellation is valid or not. Now, that was the issue before RP. So what RP did is that naturally the PPA becoming being a sole critical commercial agreement, where the receivables or the value of the corporate debtor is become very critical for the revival or for the resolution. So RP challenged it, and NCLT gave a favorable order that yes, this cancellation cannot happen because the company is into CIRP and this is very vital contract, and they cannot invoke it on the ground of and they had invoked. So yeah, so what they have done is they had invoked the cancellation basis the clause of insolvency under that agreement. So there is a termination clause under Article 9.3.1 of that PPA, where they had availed that recourse under that clause and cancelled the PPA. Now the matter was again went into NCLAT, and again NCLAT appealed the decision of NCLT, saying that see, this is very critical contract and you cannot do that. So practically the question arises, the question was that whether a moratorium or other related provisions of IBC applies to a commercial contract which are not in relation to the essential supply, and how it is to be dealt. And in this case, I think Mr. Justice Chandrachud was only there who was given this verdict. So here, if you read, so the judgment is that NCLT cannot drive its power from the spirit or object. So if NCLT is of the view that this is very critical for the maximization or the revival or the resolution, so they cannot drive it. Their powers are limited and defined under the law, that is 65C, where the IBC vests with the NCLT with its wide power, since it can entertain and dispose any question of fact or law arising out in relation to the insolvency process cost. But it can't be based on spirit or object of the court. So here, basically, I'll just read the final outcome. So what basically they have decided is that in case of PPA has been terminated solely on the ground of insolvency, which gives the NCLT jurisdiction. So because the PPA was terminated on the ground of insolvency, it made the ground for NCL to decide on that. Otherwise, in a normal commercial contract, if it is not been terminated on the ground of insolvency, NCLT cannot act or decide on that or cannot adjudicate on that termination of a normal commercial contract. So here, that's something which has been harped on, And that's why they have said that. And so in nutshell, the judgment is that because the termination was on ground of insolvency, and second, this was the sole contract which is a bearing on the revival of the corporate debtor or the CRP process. What NCLT has done is right. So they can basically stop cancellation of, or they can set aside the termination of this PPA. But practically speaking, what clearly this judgment has carved out is that in case of a normal commercial contract, where any of the parties have not honored the commitment under this, one cannot stop other who has been aggrieved by the non-performance by the other party to cancel the contract and take benefit of the respective clauses of that agreement. So you cannot take shelter of Section 14 moratorium or otherwise, which is not being clearly defined under the law, for taking advantage of, stopping the cancellation or termination of any commercial contracts. Now, in a operationally heavy, or in a company which is full of operational or otherwise also, there are many commercial contracts. Now, typically, when it comes to stress company, there is basically other than insolvency clauses, there are various other clauses in which the either corporate debtors are at default or the other party may be at default. So mainly in case, just a minute, excuse me. So mainly in case where the corporate debtor is in default, be it payment or be it any other duties under the commercial contract, one cannot stop, or NCLT cannot adjudicate that matter to decide on their termination. So that's precisely what they're talking about. But having said that, if there is a cancellation on account of insolvency ground, and basically it is something which is impacting the resolution. So both has to read together. Then NCLT has a jurisdiction to look into it. Here in the judgment, they have also mentioned that Supreme Court has mentioned that even in case where the commercial or the contract cancellation termination leads to dilution of the value of the corporate debtor, still you cannot adjudicate that matter. So in nutshell, what they were also mentioning is that if there is a major impact on the value of the corporate debtor and the ground of insolvency on which it is terminated, you can adjudicate. But if it is on ground of insolvency, but it is not impacting the value much, still you cannot entertain, or still you cannot adjudicate that application by RP, or as the case may be, for stopping the cancellation of the commercial contracts. Now, practically, when the operational heavy companies are there, this judgment is very vital, that irrespective of the fact that companies into CIRP or under moratorium, one has to honor all the payment under the normal commercial contracts. If you cancel it, see, one has to look into two aspects. One is that your dues which you are not paid, and another is basically your commitment under the contract, or other privileges which the company or a corporate debtor is having against the committed payments. Now, if the corporate debtor doesn't pay, then that leads to a ground for the other party to terminate, and they can terminate subject to the condition which I mentioned. And the second is moratorium will not apply, 2/3 cancels. And third is basically for the payment. So payments are different. Now payment is basically, if you're not paid, then it can be either for the pre-CRP period or CRP period. Now it's pre-CRP period, then they have to file a claim. For the CRP period, it becomes CRP cost. So this is all simple and settled, but that has to be looked into independently. So many times, it is easy to interpret that there is a commercial contract dispute, but there is a moratorium, no proceedings, nothing can be tendered. No. If there is a valid commercial contract where both the parties are duty bound to do certain things at a certain consideration, if that is not been honored, the cancellation can still happen. So this is the judgment which I found it critical, because today we are discussing only going concern, or rather focuses on going concern. So commercial contracts, the RP has to make sure that the commitments are honored, and then if the commitments are not honored, the CD is exposed to that risk of cancellation. Actually happen, doesn't happen, it doesn't matter much, but CD is exposed to. So again, Section 14 also has to read in this pretext and interpreted accordingly. That's something which the Supreme Court judgment is talking about. Second is about, this was a very interesting judgment which has come in case of Sundaresh Bhatt of where there are certain employees and workers who have not been paid during the CRP period, and they believe that their salaries and dues were payable, and the RP has not released that. So here in this judgment, the Supreme Court has decided that first of all, the going concern is the status. It cannot be open or at liberty of various stakeholders for the interpretation. Going concern is the status which RP is duty bound, or rather is he has. So there are very specific line which is added. So I'll just read that. It's there. Yeah. The interim resolution professionals shall make every endeavor to manage the operation of the corporate debtor as a going concern. So he has to make sure that he has to endeavor and make sure that the corporate debtor is going concern. But in case, if that is not the case, or the corporate debtor was not a going concern during the CRP despite of best effort by the RP, it cannot be presumed that it's still the corporate debtor was a going concern during the CRP period to decide the matter whether the salaries or other payments are due or not. So then finally it got concluded that it is a duty of RP, who was in charge at the time of corporate debtor, to decide that which all worker or concerned worker were actually worked during the CRP or not, and basis that only their claim will be considered as a CRP cost, otherwise it will not consider. So this is a very peculiar change, because see, here this judgment is equally applicable to type 1 company where the companies have the operations, and otherwise also where more so in case of type 2 where there are limited operations or there are no operations. Because many times what happens, RPs tend to take help or cooperation from these people who are there. Now with the operations are shut, I have seen the practices of workers going into factory, marking that attendance and creating documents against the RP that we have come, though you have called us for the work, but there was no work. So these all practices, against these practices, this judgment has given a direction that how an RP has to take care of in case of situation where there are workers on roll, but the company is not operation. So how to deal with that salaries and other payments which are getting due. Just quickly wind up because I have only 5-10 minutes left. This is only on the CRP cost that CRP cost is a sole jurisdiction of the jurisdiction, rather it's basically it is the purview of committee of creditors, and adjudicating authority cannot adjudicate on any of the cost or the quantum of the cost of the CRP cost. So so basically they are saying that it is a COC's prerogative and we cannot adjudicate. Tata Consultancy in Vishal Jain. Just a minute. Here again, so the judgment which I mentioned, so for essential supplies. So first is this judgment is peculiar on which they have concluded that the earlier judgment which I explained, where the interference of the NCLT was allowed, but they said that in this judgment that this facility agreement entered into by the corporate debtor with TCS, Tata Consultancy Services, does not stand, and the termination is valid on the same ground which I explained. So this also this judgment has a relevance on that judgment, but it clarifies the position clearly that where the criteria has not been met, then one cannot rely on this judgment or take shelter of the judgment where NCLT can decide on the termination of the commercial contract. So that in this case, the termination was valid, considering and applying the principles laid down in the earlier Gujarat judgment. Again, this is a judgment where, a quite old judgment, but still relevant, where it was clearly defined that if you don't pay, you don't become eligible for the essential supply also. So for essential supplies, you have to pay to avail them. You cannot say that it becomes CRP cost and I'll still availing and take shelter of that essential supply provisions. This is not very much relevant. This is not very much relevant. Statutory dues. Yeah, so this is basically again judgment by Supreme Court against that rainbow paper. So again, see, rainbow paper and all that was much debated, so I don't want to get into it. But yes, it has a bearing on the operations. So accordingly, it has to be taken care of. Again, I think this is the same on bearing on the rainbow paper judgment. statutory truth, and this is a going concern. So, yeah, Ghanshyam Mishra is one of the landmark judgment, which I personally believe that it's one of the classic judgment like this Swiss ribbon and the other, wherein the three core principles were laid down in this Ghanshyam Mishra judgment. And I'll tell you. So, what I believe that this judgment has actually helped in many of the processes, mainly in relation to the claim, because many a times what happens is that the claims are submitted after the timeline. So the three core principle of the main core principle which was set under this judgment was a clean slate, doctrine of clean slate. But they address these core three issues. One is basically whether the resolution plan approved binds the central government, state government, and local authority. So there was a very, various interpretation, various challenges by these authorities after the approval of plan. Whether the amendment made in 2009 by amending section 39 is a clarificatory, declaratory, or substantiative. And third is whether the after approval of the resolution plan, any creditors, including governments, can initiate the recovery proceedings regarding the dues or file a claim. So this is something which was very critical for a resolution process, and after post resolution for the implementation of plans, because this is closed on many issues of which are impacting the implementation and the issues of claim being entertained after, or how it is to be entertained after the process is concluded. So this is again a very detailed judgment. I don't want to take on that, because it's, I mean, many of you must have read and you are expert in that. So with that, I have covered all the topics for today. Now with that, if any participants wants to take up any questions, or if they need any clarification, we can take that up. Otherwise, yes, I thank you for your patience hearing and participation in the program. And thank you ICSI again for this opportunity.
Are there any questions? Participants, please ask questions if you have.
Yeah, I'll send across the presentation to the team, who will in turn can.
Yes, sir. You can send me through email.
I'll do that.
Thank you so much, sir. The session was very wonderful and informative.
Thank you. Thank you all. Thank you all for your participation.
Thank you, sir.
Thank you, sir. Thank you very much.
Thank you, sir.